things.
But on Mr. Peters, I am hoping that there will be an accusation number on the new case.
Today?
Yes, Ms. Clark is kindly checking into that for me.
Great.
So if we could just hold on a little bit longer on that one.
Sure.
I'm ready to go on Mr. Lofton's arraignment and bond hearing.
Right. If we could see if we could pull Mr. Abate, he's in front of Judge Cox on the presiding bond calendar. If he's mid-speech, he's stuck, but otherwise, it would be great to do Mr. Lofton. Oh, he said he's on his way? Okay. All right. Well, we'll see what that means. So we do need to do Lofton. We'll hold on Peters. That clears that calendar. And then our 11 o'clock sentencing of Hall, Filimon sentencing, and then Brandon Weaver. I hear that's a plea. It says Kennebrew, but is that you, Ms.? Who has Brandon Weaver? It's you, Ms. Feely. Okay, so this is the Ms. Feely calendar. All right.
Okay.
We could do Mr. Filimon right now if you want. I think that's just clearing up the loose end because the program was identified, et cetera. He's already entered a plea. We just didn't do the final disposition.
I think it really may be just a transport order issue. We may not need him.
Well, let me look.
We do a Filimon.
Just a sec. I need to look. Ms. Sims was the
Okay.
So I'm looking at the plea transcript. I don't know that we certainly talked about the program and that's why we were holding off. But I don't know that there was a discussion of what the sentence would look like other than release to a program. So I guess we would get that on the record with Mr. Filimon out here.
Your Honor, I recall you indicating that you would reserve sentencing.
I did, 100%. It says that here.
Okay.
And I think because that's how we started, you didn't make a recommendation and Ms. Feely said, we don't worry so much about the probation durate. We're trying to line up the program, but nothing crystallized. So I do think we need to have a brief conversation Wait, there's a little bit more. So it would be 10 to serve 1 year suspended upon release to pad that. So we started talking about the contours of it, but we didn't finish because there wasn't necessarily a placement. So let's bring Mr. Filimon out. I think we can tighten this up, please. All right, let's get on the record. This is 23 SC 1866547, State versus Alex Filimon. Mr. Filimon is here in court with his lawyer, Ms. Feely. Good morning, sir.
Good morning.
Ms. Clark is representing the state. Mr. Filimon, we were together in November and you entered a plea in your case to 1 count of arson. I heard a little bit about what was going on, but we delayed the question of what your sentence would be because Ms. Feely was working with you and her team to make sure that the program she had identified was ready for you so that you would be released to the program rather than being released to wherever. And we're at that time of year that was problematic for you last time, which is what led to the charges. So we just need to do that last little part of your plea. I've already accepted it. You pled guilty. And I'm going to ask Ms. Feely for her recommendation, as well as Ms. Clark, who's the prosecutor. Then I'll impose sentence and we'll figure out how best to move you forward. So Ms. Feely, tell me what your recommendation is, please.
So we are not in strong opposition to the state's recommendation of 10 to serve 1. We just are hoping that an incentive date could be proposed. And we're asking for the court to consider a shorter term of probation. I believe we talked about his lack of significant history and this extraordinary circumstances that kind of led to this. So that's our question. He's been in right at a year, as the court's aware.
360 days. Look at that. Okay. All right.
No, I sent a transport order over that has Thursday date. I'm still trying to get confirmation from Ms. Ross that Thursday would be appropriate, but it's sent over for the court to review.
Okay. And I'll certainly sign that, but you need to confirm from Ms. Ross that Thursday works.
I think it does. I just want to make, what I don't want to happen is he not be picked up on
Right.
Thursday.
I think I'll sign it. And then if it doesn't work, we'll do another one. Okay. Ms. Clark, please share with me what you think the right sentencing recommendation is in Mr. Filimon's case.
Well, Your Honor, 88 Peoples had previously offered 10 serve 2 on July 24th, and I had communicated with him a couple of weeks back, and he did confirm that that was his offer. So the state will stand by that.
Okay. Mr. Filimon, do you have anything you want to add? You and I spoke last time, so you don't need to add anything, but I'm happy to hear from you if there's something you want to share.
No, sir.
Okay. Mr. Filimon, I'm going to sentence you, having already accepted your guilty plea and found you guilty. I'm going to sentence you in this case to a term of 6 years to serve 1 year with the balance on probation. You'll get credit for all the time that you've been in. And I will sign the release order that should get you transported to the program that Ms. Feely and Ms. Ross have identified, which is policing alternatives and diversion. You'll need to be a part of that program. Ms. Feely, give me a little guidance, please, on that. PAD used to be okay if participation in the program was a condition of probation, then they weren't, because it needed to be purely voluntary. I'm interested in ensuring that Mr. Filimon is getting some support. And so I'm less interested in saying, do it if you want to. What is your understanding as to what I can do?
This may be a Ms. Tucson or Ms. Ross question. I don't know where in that flux we are at this particular moment.
Okay, well, I'm gonna make my move and we'll see what happens. I'm gonna make it a special condition of your probation, Mr. Filimon, that you participate in the Policing Alternatives and Diversion Program for at least 3 months. They're gonna provide you with support and you need to take advantage of that support while they make it available. It's not a forever program, but for at least 3 months, you'll need to do PAD, that's what we call it for short. They're gonna help you with housing, et cetera. I'm also, do you have any reason to be back at the apartment complex you were living in where the fire was set?
No, sir.
Okay, do you have that address, Ms. Clark, so that I can have that as a stay away?
Yes, Your Honor. One moment. How are you? Your Honor, it's, the address is 1177 Constitution Road, Southeast, Atlanta, Georgia, 30315.
Okay, so Mr. Filimon, there are two things you're gonna need to do. One is you stay with this program for a while, 3 months. And two, you stay away from that apartment complex where you used to live. Does that make sense?
Yes, sir.
Any questions about that?
No, sir.
Okay. Ms. Tucson, what do you need to share with Mr. Filimon about reporting instructions?
I can go back there and give him reporting instructions.
Great.
I'm writing them up now. I'll give him, address, contact, and if he's gonna be at that facility, he'll have to still report, so I could take this back.
Okay, great. Ms. Tucson's gonna meet with you just to let you know how you plug in with probation when you get released, okay?
Okay, thank you.
All right, Ms. Feely, anything else?
No, Your Honor.
Ms. Clark?
No, Your Honor.
All right, thank you. Do you want to do Mr. Weaver now while we're waiting on Mr. Abate, who is walking really slowly from 7E?
I think he actually, Judge, had to go down to 1B.
What's in 1B?
I know I had a probation revocation there. I'm not sure what Mr. Abate had, but Judge Dempsey said that it was gonna be a very quick announcement. So he should be headed back up shortly.
Okay. Well, then could we do, are you ready to do the plea in Weaver, Brandon Weaver? It's got your name on it.
We haven't, I think we're still.
Oh, it's not a plea. Someone told me it was a plea. Okay, all right, why don't you guys talk?
Judge, may I inquire, Contavious Brooks, position 7 from the 9:30 calendar?
I think that was one of our no-shows.
Okay.
Yeah, so that you know, position 1, position 7, position 10 were all bench warrants.
And Judge, I'm gonna just double check that case. Mr. Brooks was actually dismissed at first appearance in 2022. And so I just want to make sure that he got notice.
Okay.
So I'll double check that.
Mr. Brooks, okay. All right, well, I will take a break then. Let me know when we are ready.
Is this approved?
Yeah, is he here?
So he is in custody.
Oh, his lawyer filed an entry, and so Ms. Nelson was going to try to prevent him from getting brought over, but he got brought over. He's free to go. I mean, he's not. You can take him back. Because he's actually positioned for, and he's 2 and 3. He's 2 and 3, and Ms. Cabrera's got both, and she's waived arraignment.
Judge, it's my understanding that Mr. Peters, I think he might have been on the 9 o'clock calendar.
Yep.
I wasn't aware that Ms. Wood and Ms. Clark came to an agreement on that case. So I didn't actually do the waiver and do the accusation yet. It is something that I can get done today.
Okay.
If the defendant's going to enter a plea, but I wasn't made aware that he was. I know Ms. Wood reached out to me because the unindicted case is a domestic violence one. I have spoken with the victim and I'm prepared to do that.
Okay.
So I'm gonna try and get that done. I am still in Judge Eaton as well, but I can get it drafted and I should be able to try and get over to the clerk's office and get it filed. But I just kind of wanted to make sure the court was aware.
Okay, so we've got a 1 o'clock calendar. We could do it then, if that gives everyone enough time.
So the unindicted case, okay, well, Judge, never mind. It sounds like that Ms. Clark hasn't come to an agreement with Ms. Wood. I'm only navigating as to the unindicted case because it is domestic violence.
Judge, if there's an accusation number, I will put this up non-negotiated today.
Okay, great. No, you're shaking your head?
Judge, so, and I know if Your Honor is aware, we've kind of been down this road before. The purpose of the state being willing to go ahead and do the accusation is because we've negotiated a global resolution. It's not a global resolution if we are doing a negotiated resolution on an unindicted matter that the state, we do not have full discovery on yet, obviously. So I'm not going to step on the attorney who actually has the case that's assigned to this courtroom. I'm not going to step on her toes. I was under the impression that they had reached a resolution. That is the only reason the state was agreeing to go ahead and accuse.
Well, let me ask this, and this isn't for you, but I appreciate you chiming in. So, Ms. Clark, we've got a case from 2021. It's 2 years old, and the allegation is obstruction of law enforcement officer and misdemeanor theft by taking. Unless Mr. Peters broke an officer's arm or poked an officer's eyeball out, how is this not a resolvable case?
Your Honor, not saying it was not a resolvable case. Even though it's a willful obstruction charge, the events from that particular circumstance is DV and related into a DV matter, the victim in that case. And I had indicated to Attorney Wood that based on the fact that the defendant had a pending DV case, that I was going to look to Attorney Willingham to see if there was going to be a resolution. Right now, because he just had a pending DV case that he was arrested for in November of this year, I was only comfortable offering 5, serve 2 in confinement. That was my offer at this point, based on but Attorney Wood came to me and said that there was a resolution possibly and asked me for an accusation number, which is why I contacted Ms. Willingham. And if Ms. Willingham is offering a probated sentence, then I have no problem, making my part as far as the case, a probated sentence as well. But I would be looking, based on it's a DV case, I would be looking to see what Ms. Willingham is going to do on this case.
Is it the same alleged victim? I appreciate that your case, Ms. Clark, the victim is an officer, but you said it's in relation to a DV situation. Is the person involved in the DV situation from 2021 the same person who is the alleged victim in the case that is Ms. Willingham's?
No, Your Honor.
Okay.
I'm just letting you know, what the state's position was on my case, that I thought it was an easy to resolve case. It's my understanding that previous ADAs had offered, were willing to plea this down to 2 misdemeanors having 24 months of probation. Ms. Wood did forward me that. However, I had communicated to Ms. Wood that since that time, her client had the arrest for the DV case, and that I was at this point would only be willing to agree to a 5-2 because he has a pending DV case. But if she was able to get a resolution with Ms. Willingham, then I would be willing to probated sentence, then I would be more apt to do that. That was what my understanding was.
Okay. Give me 1 second. We're having a little bench situation here and we're going to have, all right. I need to step off the bench, and deal with this. I'd ask the three of you to talk a little bit more because it sounds a little circular. It sounds like we're not far apart. I appreciate your perspective, Ms. Willingham, that it needs to be something that's negotiated. I'm hearing Ms. Clark say, well, it could be negotiated if in fact, the new case isn't going to be a time served, then maybe the old case wouldn't be either. The three of you should talk. Mr. Peters is here. It'd be great to resolve all three if we can. I got to take this thing coming in from the chief judge and I will be back. All right, see if we can get Mr. Abate too. Hey, I'm on.
That was weeks ago, and she mentioned she on my case, no.
Listen, I see it. I didn't know he was here because I told him. That's a fine, yeah. And we see them. You're welcome. What time, we'll go, we got
and I said, you are, because I've done that before, where we do something.
I didn't talk to them. What are you gonna do?
That was never, I was, and I acknowledged that I was never. So no, I'm not willing to, I don't like accusing stuff unless I know, especially because it's something that I don't have all the evidence on. And so if we accuse it and it doesn't get done or negotiated, or if they don't like a plea, then we're screwed because we don't have the rest of our evidence. So I'm not willing to do that.
Right, and then, and I forwarded the email.
No, I made it very clear that you led. No, I'm saying I made that clear that you led because your case is not in mine. It's not.
I did hear it, yeah.
No, I believe you. I believe you. No, I listen. no.
Okay, I'm just saying.
No. I believe you. And then let me clarify one quick case real quick. Brandon Weaver, that's
I seen that.
right.
What calendar?
Is
I
that
don't
position one?
He said Brandon Weaver, because I didn't see that on, I was looking when he said that.
Because I was gonna say, I think you
I
all
thought
these
that was
calendars. and
on-
I don't.
It's not on these. Unless is he referring to something different.
I don't.
And the Weaver is on here. But he
Yeah,
also
okay, well
had
then
a-
I'm not, because I'm like, I didn't see Brandon Weaver when.
But I think that
Is this something did she have it here or something? I'm confused. That's what I said. What calendar is Brandon Weaver?
He's not, he's an add-on, but I wasn't CC'd.
He was an add-on.
But I wasn't CC'd.
Obviously, I still don't necessarily, it's mine. If it's an add-on, I wouldn't have looked. I know where it is.
I remember
But
that.
that's not gonna, yes, I'm just taking it right.
Okay, yeah, I sent you, maybe I can release that right there. But,
you know, the Riley situation, she had lied.
yeah, I sent you the.
One of y'all got honestly.
I do.
We need Weaver.
She was an add-on, she wasn't CC'd on.
23, 190, 176.
Before you emailed it.
Okay,
Just
so it is
for-
mine, which means I probably looked at it a little bit, but if it was.
Maybe, but when he's in portable, Is the cap case comes up.
And if it's not a
Lady case comes up, but there's no dockets in portal for full.
And she said she didn't CC me,
So
so
this,
I
when you
wouldn't.
put this case in,
She
there,
CC you, cause she thought it was, I wouldn't know.
so, but we haven't done this too, I just wanted to bring that to your attention.
Yeah, so it is mine.
Maybe it's
So, I'm not fine.
6 years, 31, and then he's going to that, the tab version. So he still has to refer to.
Notes on it?
Yeah.
You heard everything downstairs?
Yeah, he still has to.
Let me know what y'all decide.
No, we got
I don't mind using it, but I'm taking. No, that's why I said I'm probably. That's what I'm saying. She just negotiated and let him.
Yeah.
I'm not accusing unless it is an actual resolution. I'm not accusing the case.
That's why I was like, look on
No, I didn't, and I said, I didn't respond to her, you know, as long as you are, but I know I did. And I'm not doing, I told her, let me know what y'all decide, and then I will file it at that point. Hey, I'm good, how are you?
we haven't. I think we did.
Yeah, I think we haven't made findings.
That's what he said.
And I said, well, right.
The only one person?
I'm gonna sit down to Judge Keaton, and I'll come back up if I need to. I just have one plea down there, because everybody else was gone, so I have one plea, and then I can come back up if I need to.
Yes.
In the event, he's like, you know, like, but I'm not gonna do something without. Yeah.
I think, well, to me, I'm telling you, my recommendation is I want you to look at your
He doesn't like to say it's just and I'm still stuck with what I have. I don't want that to be a scenario. If this were like a final plea calendar, that might be a little bit different because you can't back out. But at this point, I don't want to put myself in that position because we don't have that evidence yet. So that's where my limit is. I mean, that ends. So, yeah.
Yeah, I understand that. But I didn't.
No, you good.
I didn't say that.
But I can.
I didn't say that.
Check your phone.
I'm with your resolution, so I wasn't really worried.
Yeah.
Whatever you trying to do. I said, Jazz, did you probation? And yes, she found me, and said, it's gonna be probation.
What's up?
But she does, I just said it to me.
Yeah, that was solely for the.
I said, yeah, would I have done probation? My recommendation is probation is so my recommendation changed. So I said,
Yeah.
Y'all let me know if you need that.
What you says driving like suspended out of college.
So, yeah, I'm gonna say my recommendation 5.2. I mean, if you're gonna get something else, that's gonna be on them. It ain't gonna be on me. Cause I feel like, what is this, the calendar with this?
That's crazy.
Hey, so this is actually not a probation revocation. If you wanna go ahead and send me an offer, so when they bring him up, I can see if this will work out this afternoon. Just letting you know.
All right. Okay.
It's a lot.
You got Mac, you got a trial with Mac?
No, I got a motion, but that's not till 3, but the victim's coming.
Oh, what kind of motion you got in Mac?
It's a special.
Oh.
It's weird because it's like traumatized cases. It's kids, so they're not gonna be able to tell you exactly when it happened to them. So usually we just charge our indictments. It could be like a whole year in which we don't know the specific date. But this attorney is challenging the fact that we said it's a whole case. It's February 1st of 2016 to February 29th. And he's essentially saying he needs to demur because we don't know a certain date, which is crazy. But my victim in that case is struggling. He's joined the gang.
Oh,
Severe, like, psychological problems, so we might have to work it out.
Anyway, just because.
Yeah, and it's 7 years old. I don't know if he's even gonna want to cooperate. So I'm gonna talk to his mom today, but she's Spanish speaking only. So, but I'll see what she wants to do.
Oh, God.
Well,
All right.
so you'll be dealing with stuff. All right, text me if you need anything.
Okay, I'll see you tomorrow.
Oh, you know,
I don't think I have anything tomorrow.
you said it's courtroom. Taking your wife to the airport or something.
Today at 3. Why? As soon as I finish the motion, because the motion was supposed to be at 3, but then we went back to 3:45.
Oh, no, because you had something, you had said you wanted me to cover something.
I said an announcement because I didn't know. I thought Adams was in the morning,
Oh, okay, okay,
but it was switched around. It's 1:30.
Okay, okay, all right, okay, well, all right,
Just text me if you need me.
okay, thank you.
You better warn.
Oh, for me.
It's crazy.
I don't know. You're not like.
Is he taking the
No, I don't blame you. So I asked Miss Nelson to. Okay. You know what's on the phone? Okay. This person has got new cases. Hold on, I made notes. So I just remember the last, he was on the calendar. These two. And he had, private attorney.
I ain't seen it go.
I don't know. So.
All right, Mr. Abate, good to see you. How was things in 7F?
Better than things 1B and then 4B. So
What was in 1B?
Quantavious Greer, so Mr. Jeffrey Williams, aka Young Thug's brother,
Yeah,
his retrial.
but you didn't just do the trial.
No, we were trying to figure out when the retrial was going to be and who his lawyer is going to be.
Okay, all right. So we have two things to tackle while you are here. One is the sentencing of Mr. Hall, and the other is the bond hearing with Mr. Lofton, and he needs to be arraigned or waive arraignment on his other case. I'm fine. We can do it in whatever order folks want to do. I don't see people here from Mr. Blunt's family. Would they be dialing in, or they're not planning on being here for the sentencing?
They are. If we could maybe do Mr. Lofton.
Oh, they're outside. Okay. Why don't we do Mr. Lofton first? And then we'll get the folks who are here for Mr. Hall. Okay? Ms. Wood, are you ready on Lofton?
Yes, Judge.
And what we're gonna do is handle the arraignment for the case Ms. Clark has, and then he's already been arraigned on the murder. We're just talking more about bond.
Correct, Judge. He does,
Okay.
and he does not wish to waive arraignment on Ms. Clark's case. He would like to be formally arraigned.
Did that happen with the murder also?
Yes, sir.
Okay, all right. Let's bring Mr. Lofton out, please.
What's your-
Oh, right. Oh, we don't make it. Okay, so.
Give me 1 second. Still working through this.
Here. I didn't know it was on the. Sorry. You need the motion.
Possession of a gun.
I didn't know it was on there.
All right, Ms. Rivers, are you ready?
Yes, I am.
All right, we're going to get on the record in Mr. Lofton's 2 cases. We'll handle the newer case first, 23 SC 190485, State versus Lofton. And this is a case that was transferred to us. Let me see why. Probably because of the old case. That's not the right case. How you doing this morning, Mr. Lofton?
How you doing, Judge Young? Doing fine.
Good. This was transferred from non-complex because of the complex case that we've got. Mr. Lofton, it's my understanding that you are not interested in waiving arraignment. You want to be formally arraigned in this case. Is that correct?
Yes, sir.
All right. That means that I am going to get a copy of the indictment. I will read it to you and your lawyer can sign it and the prosecutor can sign it, indicating your plea of not guilty, assuming you want to enter a plea of not guilty at this time. So let me first print it out. Oops, that's this button. All right, you are charged in the indictment with 2 counts. The first is possession of a firearm by a convicted felon. And the allegation is that on October 17th in 2022, you did knowingly and unlawfully, or without lawful authority, possess a firearm, specifically a handgun. And at that time, you had been convicted of a felony in case 01 CR 00400 from Superior Court of Clayton County for the offense of aggravated battery, that conviction having come in June of 2002. Count 2 charges you with a misdemeanor, and that is obstruction of a law enforcement officer. And the allegation is that here in Fulton County on that same day, October 17th, 2022, you did knowingly resist, obstruct, and oppose Officer S. Brown, who was at that time a law enforcement officer in the lawful discharge of his official duties. And you did this obstruction by snatching your arm away from the officer and resisting being taken into custody by the officer. So 2 counts from October of last year. 1, you had a gun, which you shouldn't because you were a convicted felon. And 2, you effectively resisted arrest. That's my summary of it. Do you understand the two charges that you face in this indictment?
Yes, sir.
Okay. One is a misdemeanor, which means it's punishable by up to 12 months in custody. The other is a felony, which I think these days is 1 to 10 years in custody. Are you entering a plea of not guilty to these charges at this time?
Yes, sir.
Okay, I'm gonna have Deputy Gordon bring this copy of the indictment. Ms. Wood, do you waive any issues proceeding with the arraignment from a copy of the indictment?
That's fine, Judge.
Great. And Deputy Stewart's gonna get this to you, Ms. Wood, and Mr. Lofton, if you would sign it, and Ms. Wood, if you'd indicate the not in the not guilty area, and then I'll have Ms. Clark sign the indictment as well. Mr. Lofton, you have an absolute right to counsel in connection with these charges. Ms. Wood will be representing you unless and until you hire an attorney. So she will be your representative. I will enter a scheduling order soon that will require the prosecutor, Ms. Clark, to get discovery to your lawyer, and she will review that discovery with you, and we'll take it from there. Mr. Lofton, do you have any questions about these charges?
At this moment, Your Honor.
All right, Ms. Wood, anything else in connection with the newer case?
No, Your Honor, thank you.
All right, Ms. Clark, thank you for signing. You'll get discovery once we get that scheduling order in?
Yes, Your Honor.
All right, thank you. I'll get this to Ms. Nelson. Next is a bond hearing in your other case, 23 SC 188353. And in that case, Mr. Lofton, you face much more serious charges. You are charged with murder, felony murder, aggravated assault, criminal damage to property, and related charges, all flowing from a situation in July of 2021. What I'm going to do is let Ms. Wood argue why. I don't think you are in a no bond status. I think you have a big bond, and presumably it's a bond you can't make because you're still in custody. But Ms. Wood will clear that up for me. I will hear her out. Then I'll hear from Mr. Abadi, who is the prosecutor who currently is handling your case. And I'll let you know what, if anything, I'm going to do to change your bond. Ms. Wood, when you're ready.
Thank you, Judge. One moment.
You know how they add.
Right, okay, that's what happened. Thank you, Judge. Mr. Lofton is 42 years old. He has been in custody on this case collectively 487 days. This time around, he's been in for 429 days, so since October 17th, 2022.
Can you give, I didn't hear the most recent stay you said is 129, 429?
429.
Okay, so total, there was an arrest, he made bond, and then he went back into custody?
Yes, Judge, and I'm just trying to clarify. Okay, so yes, he does have a bond in place, but when the case, it looks like when the case was indicted, charges were added. So it looks like there's 3 charges that just need a bond to be set on them.
Oh, okay.
Yes. And so that's, we'll be asking the court to set a reasonable bond on those charges today. As I said, he's 42 years old. He lives in Birmingham, Alabama. However, he has lots of family that are local to Atlanta. He could stay at an Atlanta address with his family if the court deemed appropriate. He has family support here in court today. Judge, he's eager to be able to post the bond in this case. I'm not sure if you noticed, but he has an injury that cannot be operated on while he's in custody. And so it's our understanding that he needs to be out so that he can actually get the treatment he needs for that. He's also having issues getting his prescribed medication at the jail. We are working with the team at the jail to make sure that that gets rectified, but that is a concern of his. Judge, he is married, he has children, he has no issues with being on an ankle monitor. He's not a flight risk, he has plenty of community ties, and it's my understanding that he has only one failure to appear in his past from when he was young, and it was not even, he was incarcerated elsewhere, so that's the only reason he missed court that time. Judge, but we're just asking the court to set a reasonable bond on the charges that are in no bond status.
In January of this year, Judge Dallas set the bond, and it included a requirement that Mr. Lofton reside at an address on Burrough Avenue, Burroughh, here in Atlanta. One, is that still a valid address? And two, what is that address? Or who is there that he's connected to?
That is his grandmother's local address, Judge. And I'm sorry, I missed the second part of what you were asking.
Oh, so you actually answered the second part, which is how is he connected to that address? The first part was, is that still an address where he could stay if I decide, at least initially, he's going to need to be local?
Yes, Judge. Still, yes, Judge.
Who else lives in the house besides grandma?
Her husband, Judge.
Okay. And the location where the alleged shooting occurred, that's anywhere near Burrough Avenue?
It's Bankhead with it alleged.
That was the allegations are from a community
Hall.
block party, so it's not like a home address.
Okay. There was an event.
Yes.
Got it. Okay. So Mr. Abadi, this is a slightly different posture than I typically encounter with one of your cases. There's already a bond in place, but that was before the indictment, and now there are more charges. But judicial officer, it looks like twice, concluded that bond was appropriate. It's a big bond, but they're serious charges. I'm curious how you think we ought to move forward with Mr. Lofton's case.
So I have a different understanding as to why the defendant is currently in custody. He was released on bond, and then bond was revoked due to his new allegations or new charges.
Meaning the firearm case.
Yes.
Okay.
He had a previous bond that looks like it was surrendered by Jet Bonding Company back on 10/7 of 2022, which I believe is right before or 10/17. I can't read this lady's handwriting, but it was October of 2022 when his bond was surrendered. So he may have had a bond, or a judge may have believed bond was appropriate at some time, but it was revoked due to violations of his bond.
Okay, I see that. So the incident in his newer indictment, the incident date is October 17th, 2022. So it may well be when he was booked in, Jet said, we're coming off the bond from 2021 that was set for Mr. Lofton in the murder.
Correct.
That was set by Judge Farmer. And that's the $350,000 bond. And that has that address. So I guess I'm not quite sure why Judge Dallas was handling a bond and a murder, other than that she said it's been 94 days and he hasn't been indicted. But that would have been 94 days after he lost his bond and had been arrested on new charges where he had a gun, allegedly, after a case that involves allegations of shooting a whole bunch of things.
Correct. And so the 94 days is a arbitrary number as it relates to, bond in the 2021 case, because we had already surpassed the reason he got the original bond was because of the fact after 90 days after being charged with the murder case, he wasn't. So he received the first bond from Judge Farmer after getting out is when he committed this new offense with a firearm, and he was taken back into custody. So
Okay.
So I would, submit to the court that one, he is not an appropriate candidate for bond. He does have 3 prior failure to appears. two in Fulton, those being in 2004 and 2016. He also had another in June of 2016 out of Fayetteville, Georgia. He, I would submit to the court as a threat or danger to the community and the people in it, in the sense that the defendant is at least a two-time convicted felon, and still continues to use and carry firearms, and most recent as October 17th of 2022, making him a danger to the community. Based on that and the allegations in this case, the defendant is alleged to have fired multiple times and several occasions on the evening in 2021 into a crowd of people during a block party, which led to kind of a melee of shots and Mr. Parker being killed. I would, I guess, submit to the court that the delay in the case involved the fact that there was an officer who discharged his firearm, which led to complications and, making the investigation a little lengthier than a normal case. That officer was completely cleared based on all the camera footage that was recovered, whether it be video surveillance camera footage and body camera footage, which captures the defendant firing for absolutely no reason into a very large crowd of people who were trying to enjoy a block party. So based upon that, Your Honor, and the defendant violating the conditions of the prior court, Judge Farmer, who set his original bond, I would submit to the court that he is not an appropriate candidate for bond at this time and should remain in the custody of the Fulton County Sheriff's Department.
All right, I was just looking at the two cases in Odyssey. Where are you, Mr. Abadi, in terms of providing discovery to Ms. Wood? We've got a final plea date early next year, and then a trial date also early next year. Are there things you're missing so that Ms. Wood wouldn't have them, or where are we in this?
So I would, I'm pretty positive everything has been turned over because of the fact that an officer was involved in, the case, and there was an investigation as it relates to him. All the ballistics evidence has been thoroughly tested and things of that nature. So it'd be my contention to the court that every piece of discovery has been turned over, at least that's in the state's possession. I'll continue to thoroughly go through it to make sure that we have everything. And if not, I will turn over anything I newly discovered in this Wood.
Okay. Ms. Wood, tell me where you feel that you are in terms of having received discovery, not in the new case, brand new, you'll get that. Although in looking at the warrants, at most, I think maybe you'll get some body cam footage or something. But in the more serious charges.
I do. I have what I believe everything that Mr. Abadi has. I also will get with him today. I have a question about something that I saw in there. But we're in a good position with that so far.
I know you've been very diligent. I've signed orders that let you get into the jail with a laptop so you and Mr. Lofton can review digital evidence that you can't leave with him. And I'll continue to do that. Is there anything you want to add on the bond conversation, having heard from Mr. Abadi?
Yes, I want
You can address the court, just don't get into the facts of the case.
Right, but I also want to say that I have one phase with the 903, so I'm gonna address the question.
Okay. That's fine. Judge, so Mr. Lofton does want to address the court, and he also wanted me to clarify that he maintains there's only one failure to appear from many years ago instead of the three. And so, yes, I will let him speak to the court now.
Okay. So, Mr. Lofton, I'm happy to hear from you. I trust Ms. Wood has already said this. It is not in your best interest to talk to me about the facts of either of your cases. And so if you start to, and Ms. Wood elbows you, she is protecting you and not interrupting you. But why don't you tell me what you want to tell me?
Your Honor, first I want to say good morning. I hear what they saying and about me, but that's not me. My wife and my mom here, like I said, I have ties here in the community. I'm from here, from the area, where I made my innocence on both cases. The reason I was saying that bond would be appropriate today, I got to get back to my wife, my family, due to finances, and we have to not have my lawyer and get hired the public defender, and different things with my surgery and just getting back to life, you know, because this has been a pause for my family, and I understand what they think they have and what they saying is that's not the situation, but I've been shot, and I have, you know, mercy for the family that person got shot also, and it wasn't me. And we have ties, like I say, in the community, in Birmingham, Alabama. You know, I'm tied in with the police department down there training. Me and my wife was owners of the gym, and you know, we go out to the community, to the youth, and spread them not to be in this type of situation. You know, as I was on Anchor Monitor, I was going to different housing authority projects down there, talking to, like I said, the youth and trying to encourage them not to do this, but, you know, dealing with mental health issues and substance that, you know, I'm here today. But I just, you know, pray to God that all this go behind me, and I just put him first in my life. And I just say that bond will be appropriate so I can get back to doing what I need to do to raising my family and moving forward in life and get this behind me.
Okay. Well, like you, I'm anxious to get this behind you. You've now got two things to get behind you, some real serious charges, and then the more recent ones that are less serious, but to me are an impediment for you getting a bond. The primary thing you're supposed to do when you're on bond is to show up, and you've done that. I'm not worried about the FTAs. But the second thing, and it isn't all that much less important, is to show everyone that you can abide by the law. And getting arrested for, I appreciate you're presumed innocent, but this newer case is not a particularly complicated one. You either had a gun in your pants pocket or you didn't. Officer says he found one, so the officer's either lying or you had a gun and you weren't supposed to have a gun. That was against the law. It was against the conditions of your bond. And really, it's the last thing you ought to have on you when you're facing a murder charge and multiple other shooting victims in that case. That's not me saying you did that other thing. It's me saying that that is probably one of the worst things you could do while on bond if you want to convince a judge, hey, don't worry, I got this. I got everything under control. It's safe to have me out in the community and I'll come back. I'm not particularly worried about you coming back, but I am worried about that other stuff. You were one of the last people in the metro Atlanta area who should have been walking around with a gun with murder charges hanging on you. And yet this situation happened. So I'm going to not modify bond right now or amend it or add to it in any way, but I will do this. We've got some good, pretty aggressive deadlines to get a jury here to hear the case, because it's not my decision, are you innocent of these things or not? A jury needs to decide whether the state can prove the charges against you or not. And we've got a trial date coming up soon for that. The one caveat I'll put in all that is that Ms. Wood's going to get the discovery in your newer case. And I appreciate it's still kind of old. It's from October of last year. And she's going to go through that. And if she sees some problems in that case, then I'm going to encourage her to litigate that up front, because if I learn more about that new case and it really is, you didn't have a gun, but an officer planted it on you, or you were near a gun, you were in a car and there were 4 people and there was 1 gun. I mean, that's really not yours. That's not the allegation. The allegation is it was on you in your pocket. If the evidence is otherwise, then I ought to rethink this. But for someone who was on bond for shooting and killing someone and shooting and injuring other people and shooting up a car, not saying you did it, but those are the charges, for you then to get arrested after that while on bond, having a gun, tells me we don't need you in circulation until we clear all this up. And if the jury says Mr. Lofton was the wrong guy, state didn't prove its case, then you're back to your gym and your family and being out in the community. If the jury sees it a different way, then you're in the right place right now anyway. Ms. Wood, anything else on behalf of Mr. Lofton?
No, Your Honor, thank you.
You will let me know, as I'm sure you will, if as you review the discovery in the newer case, if you see things that we ought to litigate post haste, that we can do that so that I might learn more about the facts and circumstances of the new case. Short of that, my focus will be on getting Mr. Lofton into court on the murder charge, because that's, of course, the more serious set of circumstances. Ms. Clark, anything else on behalf of the state for the newer case?
No, Your Honor, none for the state.
All right, Mr. Abadi, anything else?
No, Your Honor.
All right, thank you, everyone. Let's get Mr. Hall out here, please. Oh, yes, okay.
Thank you. Thank you, Bill. Tried. Figured one time a year. I'll do it.
So we don't have the room for.
Yeah, if you want to let people be coming in while that happens, you tell them to sit wherever you want them to sit. Maybe we can do 2 for 1. Oh, they just brought them out.
You got it.
Sorry. I have some things for you. Haven't done one of these in a while. And
I didn't make any copies because it changed the year.
yeah. What's that other form about demanding arraignment? Yeah, no, I'm sure I did. I just.
At the end of the year, I just.
Yep. Got it.
Do you have, after the sentencing, do you have any other matters scheduled for our probation revocation?
We've got the Hall sentencing. I don't know what we're gonna do with Weaver. Do we have an update on that? That's still conversating?
Yes.
Okay, so yes, but we won't do it. I at 12:30 have to be on this emergency Zoom call with my colleagues. So we will do this sentencing between now and 12:30. And then the courtroom will be yours for a half hour, or however long that meeting takes. And then we'll turn to what's left over and the revocation. Does that?
Well, yeah, that answers my question. I just don't want to set this board up in your way.
No, so you should feel free to set it up during that break when I gotta go get on this call.
I'll be back until 30. Thank you.
Sounds good?
I just got your email. Here we go. I don't mind. Oh God, sorry.
Oh, this burn. Yeah, I'll show you, put your phones away, and it's off. Thank you. I'll just write that down. Okay.
Oh, yes, bring him in, please.
Okay. Okay, a wheelchair. No, she's not in a wheelchair. No, okay. Yes, ma'am. Thank you.
Glad they did that null pros. Mr. Jordan's like, can I do the null pros by Friday?
You think it'd be okay if I say?
Yeah.
Say something, you think that's not said no?
Oh, you got to do this.
Yeah.
Make sure they're turned off and away. Make sure your phones are turned off and put away. Make sure your phones are turned off and put away. Just a regular it's a regular church.
Oh, Lord, people, I want to find my people up there. Yeah, big mess.
Make sure your cell phones are turned off and put them away in your pocket before you turn. You can't use that sometimes. So, just be off while it's there. You won't be able to take things out. Okay, thank you.
Mr. Abadi, you ready? All right, let's get on the record. Ms. Rivers, are you ready?
Yes, I am ready.
Great, thank you. We are here in 22 SC 184215, State versus Jason Hall. Mr. Hall is in court with his lawyer, Ms. Feely. Mr. Abadi is here for the state. And we are handling sentencing in the case. Mr. Hall went to trial, and a jury on the 14th of last week found Mr. Hall guilty of the murder of Mr. Blunt, along with some related charges. I will be hearing from the state first to include any victim impact statements, and then I will hear from Ms. Feely. And if Mr. Hall wants to say anything, he's free to do that. He has a right to do that. I want to first address everyone who is here, presumably on behalf of Mr. Blunt. Welcome. This is a public proceeding. It's great that you're here. It is important that if you have anything to express, you do that only when Mr. Abate recognizes you and you come up and we can get on the record what you have to say. If you're going to have any trouble otherwise sitting there quietly, I'm going to ask you to step outside. You do not want to disrupt these proceedings. The jury has spoken. They found Mr. Hall guilty of the murder of Mr. Blunt, and we're going to talk about sentencing. And it is appropriate for me to hear from any number of friends and family members of Mr. Blunt, and I'm prepared to do that. But we need to do that in a way that is orderly and can be taken down and doesn't cause any disruption. So if anyone thinks he or she is going to have trouble sitting still and listening, feel free to be outside. You can plug in through YouTube, but we need to not make any difficulty for the deputies. All right. With that, let me tell you where I think we are. I think that count 2 is vacated by operation of law, and count 3 merges into count 1. And so really what we're talking about is a sentence for the count of murder and the sentence for the possession of firearm during commission of a felony, which is 5 years and has to run consecutive to count 1. I'm open to legal argument as to some other way of structuring the sentence, but I think that's where we are legally. And Mr. Abadi, I'm happy now to hear from you in whatever order you want to present things.
So I would agree with Your Honor. Those are the 2 charges based on the laws that count 2 felony murder would vacate, and then count 3 would merge with count 1. If it's okay with Your Honor, I figured we'd just start with some of the victim impact statements. There are 4.
Oh, and let me add this. I'm sorry. It is sometimes folks want to speak directly. Great, happy to do that. If that's going to be difficult, we have an amazing victim advocate here who can also read your statement. Either one is fine. It is no less impactful for me or the listening public if the victim witness advocate reads it for you, but it's also fine for you to address the court directly.
Thank you, Judge.
Sure.
So we're going to start with Ms. Bell.
And what will, great, we're having him sit right there. Perfect.
Speak right into the microphone. State and spell your name for the record.
Can you turn the camera on? It will help Ms. Rivers take this down if she can see the person speaking. Great, thank you. You look great, Ms. Bell.
Thank you.
All right. Saw you adjusting your hair.
Yes.
So if you would, each of you who's speaking, if you could start by sharing your name and your connection to Mr. Blunt, and then anything you want to say after that.
My name is Vicky Bell, and Corey Antoine Blunt was, and he was my grandson. Good afternoon. Your Honor, on behalf of myself, Vicky Bell, Corey, and his other grandmother, Miss Gloria Hurd, and his entire family and friends, we would like to say thank you to you, Your Honor, the jury, his terrific 3 lawyers, Ms. Sherry for being there, and the officer that stood by my family in this devastating time. Mr. Jason, if you only had gotten to know Corey, you would have found out that he was a good young man. You would have beaten him in playing pool, but he would have got you in basketball and video games. His friends missed their energizer partner, their cook, their rap partners, because he could rap pretty good. My mama found that out. Their advisor, and for them calling him, and he would be there for them at any time. Corey's favorite word was I grieve by having pictures along with his mother and Corey on my wall, all over in my house. That's the way that I'm grieving. I talked to him, and I really love and miss him. He looked up to his uncles for advice, and his cousins looked up to him. You have ripped our heart out of our bodies, but Corey is strong and here to let us know that he will help us mend our life back together. We miss him. When you go down the road to your place of home, you will meet other young men younger than Corey who will be checking you. What you gonna do then? I thank you, Your Honor. We miss you, Corey, and we love you.
Thank you, Ms. Bell.
For the record, this is Miss Taylor Roddy, Roddie.
Good morning.
Good morning. How are you?
I'm okay. How are you?
I'm
All
okay.
things considered.
Right. I'm okay. My name is Taylor Roddy. I was Corey's cousin. I knew him as Little C, and I just want to talk a little bit about who Little C is and what he embodied, kind of echoing Grandma Bell, but he was loving, caring, he was a protector, and he had a smile that lit up the entire room, whatever space he entered into. A memory that I'm gonna have to hold on for the rest of my life was 2 weeks before this awful event occurred, which is when he turned 21. And his family was around him. We were all laughing. He was smiling, telling me about all the things that he wanted to do moving forward with his life. And I am saddened and enraged that we will never get to see that from careless and reckless actions that could have been 100% avoided. It could have been avoided. And so I'm here holding as much restraint as I can, but I'm angry. I'm infuriated because it wasn't necessary. So to the defendant, I hope you never know peace. I hope from the moment you wake up and open your eyes to the moment you close them, you hear the cries of his family. You hear the sorrows. I hope you never know peace, because there was a way that this could have been resolved with nobody losing. Because not only was Little C's life stolen, we had something stolen from us as well. So to you, Judge, I ask that when you render your sentence, you don't consider mercy or leniency, because it's not deserved. Thank you.
Thank you, Ms. Roddy.
For the record, next family member is Miss Miranda Raines, Raines.
Good afternoon, everyone. My
Hi there.
name is Miranda Hurd Raines. Lil C is my little cousin. Me and his father are first cousins. We're 4 days apart. And like my little cousin said, like Mama Bill said, little Corey, when he come in the room, he would light it up. He had the smile. Oh my God! I mean, he was just so brilliant. He would sit down and talk to you, have conversations with you. I mean, he was just a loving young man. And like my little cousin said, 2 weeks after his 21st birthday, this man decides to take his life because he felt like he was being checked. I am furious. Like, we will never know what he would become. We'll never know. For him to say, and I want to thank you too, Judge, for having this on YouTube, because I was not able to make it to the trial, but I watched it on YouTube, But for them to say that, oh, he came in there aggressive, you could barely hear Lil Corey talk, even when he was mad. You'd be like, speak up. I can't hear you. He was, never no aggressive type person. And Judge, I'm asking you to never let this man see the light of day. He don't deserve it. My little cousin never had no kids. He took my cousin, Big Corey, took his only son from him. He should never see the light of day. He should get the max on each and every charge he was found guilty on. And I just wish I could be a fly on the wall to see how many times he gonna get checked when he go down that road, because he will be getting checked. Thank you.
Thank you, Ms. Raines.
Your Honor, I believe we have one more family member, Mr. Jalen Finley, Finley.
All right, Mr. Finley, come on up.
I'd like to say good morning to everybody.
Good morning.
And really just speaking from my heart, off the top of my mind, I'm speaking on behalf of all of Corey's friends and homeboys, brothers, whatever you like to call us. Every 30th was like a day that we would never forget, that changed everybody's life in this courtroom, people that's watching from the Zoom call, even people that just crossed Corey's path in life. And for us not to be able to see him today, it can like mess up a whole lot of people's lives, and it is messing up a whole lot of people's lives. And Corey was really like just that good person that if you was down, he was gonna be down with you till you got back up happy. If you was sad, mad, crying, whatever it was, he was gonna make it change before he left the room or before he left the scene or anything. So I just hope you give him like max charges and he'll never see the day of light, because he actually took a good person off this earth, a person that even he could have been younger than some of us, he looked up to us and looked out for us like he was the big brother and knew more than what anything that we could know, just because what his family instilled into him. So I appreciate the lawyers, the judge, you, everybody that put into this case to make it get far as we got it today. And long live Corey.
All right. Thank you, Mr. Finley.
Your Honor, I believe that concludes all the victim impact statements for the number of family support and friend support that the victim in this case, Mr. Corey Blunt, has here today. The state is in agreement with the court as it relates to the charges for the defendant to be sentenced upon. As to count 1 murder, the state's recommendation would be life, the mandatory sentence. As it relates to count 4, the state would recommend to the court that the defendant be sentenced to 5 years, obviously consecutive as required by law, but for the defendant to serve for a life plus 5 sentence.
All right. Ms. Jackson, good morning, and thank you for joining us. Can you share with me whatever criminal history information, if any, that you have as to Mr. Hall?
Good morning, Your Honor. He does have a total of 12 cycles.
The last arrest was July the 27th, 2012 out of Gwinnett County for a DUI. And he does have one misdemeanor conviction that was in 2013 out of Gwinnett County for 2 counts of a DUI. Nothing in addition, Your Honor.
Thank you. Appreciate it. Ms. Feely.
There's not a whole lot to talk about, given the court's options at this point. We are asking the court to consider the mandatory life sentence with the 5 suspended on the gun charge. No sentence is going to bring Mr. Blunt back, and we're just asking the court to consider that there's nothing aggravating about Mr. Hall's circumstances in terms of he doesn't have a criminal history. He's 42 years old. He probably would have lived another 42 years, not a convicted felon, which is how he started this case. So we're just asking the court to consider his lack of criminal history, the fact that he was living, working, doing everything he was supposed to do, and does not have a felony conviction until now. And so we're asking for the minimum.
All right. Thank you, Ms. Feely. Mr. Hall, you have a right to what we call allocute, which means share with me anything and everything you want to, but that can include saying nothing at all. If you do decide that you want to say something, make sure you say it to me. It may be thoughts or sentiments directed elsewhere, but you and I are the one having a conversation. But I want to reiterate, it's not obligatory. If there's something you want to share, now is the time to do it. But you can just rely on what your lawyer had to say.
I'm good.
You're good. Okay. Well, you're not quite good. I'll tell you that. It's my turn to talk about the case. I have the unenviable role of sitting through way too many murder sentencings. And this one has been fairly unique in that I heard from multiple family members who weren't just grieving, but remain so very angry. It is seldom that I hear people say no mercy. There are victim friends and family members who are grieving, but they leave it to God and others to figure out what's going to happen to the person who's been found guilty. It is clear to me that your lack of control and restraint in April of last year took away someone exceedingly near and dear to a lot of folks. A young man whose story will remain untold. Was he going to be an amazing musician, a dad, who knows what, and maybe all of those things. And that's a story that all these people are going to have to invent for themselves. I hope that they can channel the love and passion that they had for Mr. Blunt into another friend or relative, because clearly he evoked a lot of care and affection amongst all these people. It sounds like he was a good kid, and you shot him dead. And there's no excuse for that. And that's something, as several other folks recognized, you're going to have to process as you navigate life in the Georgia Department of Corrections. Mr. Hall, I'm going to sentence you to a term of life for count 1, followed by 5 years to serve for count 4. This is not a sentence that magically brings Mr. Blunt back to life. It is not a sentence that heals the wounds that I heard, but I do hope for the friends and family of Mr. Blunt that this process brings a little bit of closure. It doesn't return Mr. Blunt, but it shows you that folks cared, folks who didn't know Mr. Blunt, Mr. Abadi, Mr. Hiles, Mr. Rao, they didn't know him, but they focused their energies on making sure that justice was done. You had 12 strangers who didn't know anyone in this mix give up a week of their life to listen to the evidence. And it was difficult evidence. Those videos were awful. And they were clearly very thoughtful jurors. They didn't go back there and in 5 minutes say guilty or not guilty. They struggle with this. And they've done the community a service by speaking the truth of what this case was. It's not the police saying we got the guy. It's not a judge saying, oh, this is how it needs to be. But it's members of the community who've lived lives like Mr. Blunt or Mr. Hall or any of us. And they've spoken. And my hope is that for those who are grieving, it offers some solace that the process worked and it cared. The process is not over. Mr. Hall, I need to share with you your appellate rights. you have the right to a direct appeal, and you can pursue that appeal in two ways. You can pursue it in both ways or just one, and Ms. Feely will talk to you about this. You have the right to have a motion for new trial, and I'm going to ask Ms. Feely to file something on your behalf at your direction in the next few days. A motion for new trial is when a lawyer, and it won't be Ms. Feely, you'll get another lawyer appointed to represent you, looks at the trial transcript and attacks it where that lawyer sees that mistakes were made. Mistakes I may have made, mistakes your lawyer may have made, which is why we get you a different lawyer. That motion will be heard by me. You will be present for the motion. You may be present virtually because if you're not testifying, then you'll be watching from whatever prison you've been assigned to. But a lawyer will pursue that if you want that to happen. You also have the right to a direct appeal to the Supreme Court of Georgia, where a lawyer will make arguments about errors that were allegedly made during the course of the trial. You can do both. If I deny your motion for new trial, you can then appeal that to the Supreme Court and basically have a second argument, same issues, but with the Supreme Court looking at it. Or you can skip the motion for new trial, if that's your pleasure, and go straight to the Supreme Court. Whichever you decide, motion for new trial or direct appeal to the Supreme Court, Ms. Feely needs to file a notice within 30 days of today, because I'm going to enter your sentence today. And that starts a clock ticking. If Ms. Feely files motion for new trial or notice of appeal, that stops the clock. We'll get you that new lawyer. That new lawyer will get the record and we'll figure out what he or she wants to do. Do you understand your direct appeal rights?
Yes, Your Honor.
Will you talk with Ms. Feely about what you want to do?
Yes, Your Honor.
Ms. Feely, you'll follow your client's directions.
Yes, Your Honor.
You have a second line of appeal that you can use after you exhaust or abandon your direct appeal. And that's what we call habeas corpus. And that is a right you have within 4 years of either your abandonment of any appeal. In other words, if 30 days pass and Ms. Feely doesn't file anything on your behalf, that 4-year clock starts running, or at the end of all your appeals. So if the Supreme Court affirms your conviction and sentence, then a clock starts running that's 4 years long. And within that window, you can file, it's a civil lawsuit, but you're basically attacking your conviction and the performance of your lawyers, et cetera. You don't have the right to an attorney for that. If you can afford to hire one, you can do it yourself, but that's something that you can choose to do after you're done with your direct appeals. Do you understand that?
Yes, Your Honor.
Any question about your appeals?
No, Your Honor.
Ms. Feely, anything else on behalf of Mr. Hall? Mr. Abadi, anything else on behalf of the state?
No, Your Honor, thank you.
All right. Thank you, everyone. We are adjourned.
Thank you.
Doesn't start.
Yeah, sure.
Jump right into the 1 o'clock calendar.
We're going to clear up Peters and I think that, and Weaver. I don't know what's happening with Weaver. That's a Feely thing with Ms. Willingham. And then whatever we're doing with Peters. So I'll get closure on that. If Ms. Wood was around, you can tell me, what are we doing with Peters, do you think?
I told her, I think she may go non-negotiable.
Okay, but will Ms. Willingham go forward? I thought she said it's not.
No, so Ms. Willingham, I think there was a misunderstanding on their part, or whatever. Ms. Willingham indicated that she had not even reviewed discovery. She was only going to make a probation offer and recuse the case if we had come to.
Got it. So what we may do today is a non-negotiated plea to the indicted case, and the unindicted one will go wherever it goes. Won't come here, it'll go wherever. Okay. All right. Ms. Feely, I'm going to interrupt you real briefly, and then you can stay focused on Hall or whatever else. Mr. Weaver's still here, and we can at 1 o'clock take that back up. Have you been able to speak with Ms. Willingham?
So this may not have been enough notice since I was emailing the wrong DA last week, so.
Oh, who did you think?
I CC'd Ms. Clark.
Okay.
So that was my error, and so I don't know that she's had enough time. It's a false imprisonment case, so I think there's.
It is. Okay. Oh, so she needs to reach out to the victim?
I haven't, there was some email traffic back and forth. I haven't seen it.
Okay, we'll see. I'm not abandoning it. I just was curious. Ms. Clark had asked what we do at 1, and my thought was that we'd close out whatever we're doing with Mr. Peters and with Mr. Weaver. So you got an hour to track Ms. Willingham down. And Ms. Wood, I asked Ms. Clark what she thought was happening. She shared with me that it sounds like with Mr. Peters, you may put up a non-negotiated plea to just the indicted case.
So there's some massive breakdown in communication. I will try to clear that up with the state.
Okay.
And then we'll see what happens.
Okay. What we'll do at 1, assuming I have to get on this emergency session at 12:30. It's not like fire emergency. It's like courts bonking heads together, county commission type emergency. So it's political, but that's at 12:30. I don't know how long it'll last, but I'll come out here as soon as I can. So it'll be 1-ish. And what we'll do at 1-ish is see what's going on with Peters, see what's going on with Weaver. And if those are, Weaver is Ms. Feely's.
Yes.
If those are resolvable, great, let's do it. Otherwise, it'd be great to resolve some of these. If not, then we've got Mr. Hiles's big revocation and we'll go forward with that. And that doesn't involve any of you. And we'll see you the next day.
And Judge, I'm not sure if anyone talked about Anthony Kennedy while I was out. Was that brought up?
I heard that no one substantively, I heard the name though.
It's listed on the calendar as a probation revocation. I think it's actually not a revocation. I think it's maybe a bench warrant.
What calendar is it on?
It's on the 1 p.m.
Oh, it's a 1 p.m. Okay.
Yes.
Got it.
So I'm just putting that on your radar as well.
Didn't come up with anything. Don't have him reported at all. He has 2 other cases he's on probation for, in Clayton and DeKalb, but he's that docket number.
Okay, I see. Position 1 this afternoon, Anthony Kennedy, it says probation revocation. There's an FTA, so that may be it. But is he in custody?
He is, Judge,
Okay.
and it's a 2018 case. I would love to resolve it, so we'll see what we can do.
Okay, so Ms. Clark, you'll talk with Ms. Wood about potentially resolving Mr. Kennedy's case.
Yes, sir.
Great, all right,
So it might be a plea, basically.
right.
Not a-
Recess, Judge?
Yes. And Ms. Wood, I need to talk to you for 1 second
Yes.
before you run off.
Okay.
Are folks doing okay? Good.
Judge, so what time?
1 o'clock? Yeah, oh, let me mute it. Let me put that on the screen.
Okay.
You can just go on through. I'll get you right there. Yes, sir. Thanks for your time.
Judge McBurney.
Okay, sorry, things were muted here in court. I don't know who just reached out, but, oh, it was Ms. Clark. Okay. She's at the office. That's fine. I got the microphone back on here. And we have for now navigated our institutional crisis. No, I need to deal with this and then we're going to figure out, we had two other matters that we were going to sort out. And then we'll get going. Is Mr. Robinson's lawyer here? Right there. Hey, how are you?
Good, how are you?
Thank you for diving into this one.
Of course.
Okay, Ms. Wood, Mr. Peters, are we able to do anything today with Mr. Peters or not? Or should I ask Ms. Clark?
Maybe ask Ms. Clark. Judge.
Okay, I'll ask that in a minute. How about Ms. Feely, Mr. Weaver?
So the email traffic has stopped, so I think this is one that we just are not able to do. I put it on there thinking it was low hanging fruit we could knock out, but I've spoken with Mr. Weaver. He's hopeful we can add him to a January calendar and we'll all have our.
Let's do it. And if Ms. Willingham resurfaces for some reason, there's, I mean, maybe later this week, I don't know. I'm not promising. Ms. Nelson may jump on me, but if there's a way to resolve it, let's do that. So you've talked to him and they can send Mr. Weaver back. Well, I guess, is he already on track to be on final plea someday and you were just jumping ahead, which I always encourage?
Yes, I think he maybe.
Let me look. He's got final plea in March. So that's lots of time. If you can sort something out with Ms. Willingham before then, let's bring him in. Okay. Ms. Clark, are you still on? You are on. There you are. You just nodded your head. Are we able to do anything with Mr. Peters or should he go back? You're on mute.
My apologies. I made an offer to the defendant, 5 years served 2. And I did further research on the case. Actually, the victim in this case is actually the same victim that's in the DV case.
Okay.
And so based on that, the state is comfortable with the offer of 5 served 2. I mean, excuse me, 5 years served 2 in confinement.
Got it. Okay. So Mr. Peters could nonetheless enter a non-negotiated plea today on this case, but it wouldn't resolve the other case. And he'd need to sort through that. I'm open to whatever. I don't know what Mr. Peters is open to.
So I think the issue, Judge, is that he was hoping to take care of both of these at one time. He has some state court matters that he's also got to deal with, and he also has a DeKalb County hold.
Oh.
So I was trying to take care of this so we could move it along.
Yeah. Well, why don't we hold off, because now that I understand that this isn't something that would get him out if I decided to, I don't know how long he's been in, but assume for a minute he's been in for about a year, and that's the sentence he got. He wouldn't get out. I don't know if state court's holding him. At a minimum, he'd go to DeKalb. He's in through the end of the year. So why don't we do a reset, and early in the new year, you can plug in with whoever's managing the two cases on the state side, and we'll try again. I don't want his situation to get more encumbered. And of course, I don't have him on anything. Oh, because I guess he was a bench warrant status for a while.
Yes.
He's not even, all right, so we need to get him on a final plea.
Sorry.
I'm sorry, Anna. She wanted me to tell him, but I was saying, do you want to bring him to the door?
Oh.
Yes, so Judge, he was on a trial calendar last
Oh, look
year.
at that, in April of last year. Okay. And so we should just put him on another trial calendar. And if between now and then we can sort things out with this and the unindicted case, great. But we ought to get him retracked to a trial calendar.
Yes.
All right. I'm sorry, Sarge. I didn't know you were helping her with this as well. And I'm sure she asked you rather than, yeah. All right, Ms. Wood. Okay. So do you want Mr. Peters to come to the door and I'll tell him anything, or you're managing this?
I can pass the note, Judge. He's just in the wheelchair, so.
Yep. Okay.
Keep it moving.
So really then the only person we need to keep up here is, we've got Mr. Kennedy too. Kennedy and Robinson. Everyone else we're done with. What do we know about Mr. Kennedy's situation?
So Judge, this was listed as the revocation. It's actually a failure to appear from 2019. He has been in DeKalb County Jail since that time. I think that's actually why he missed court here. So it looks like it was arraigned during Judge Reeder's time.
Yeah, it's one of these where there's no arraignment in the docket. There's an entry of appearance, I'm assuming by Mr. Franklin, I'm calling it up now. But she tended not to, and it could have been the litigation manager. We wouldn't know that something was arraigned. So I want to start a clock with him for you to get discovery, et cetera. But it's certainly not a probation revocation. As Ms. Tucson was pointing out, this is a guy who he's got an indictment from 2018 for burglary. So do you want to waive arraignment today and get a scheduling order in place?
Yes, sir.
Did you chat with Ms. Clark to see if this is something that can sort out today?
Yes, Judge. Over the break, I did reach out. I am not sure if she's prepared to make an offer. Mr. Kennedy is eager to wrap this up and go to his Clayton County hold.
Okay.
So if it is something we can resolve today, I'm happy to do it, but I also understand.
Okay. Well, why don't you do this? Why don't you reach out to Ms. Clark through email, phone, whatever, while I turn to the matter with Mr. Hiles. And if it's something we can sort out, great. If not, if you'll fill out that waiver of arraignment, we'll get a scheduling order in and we can have this move at a faster pace than some of the others, given its age.
Thank you, Judge.
All right, Ms. Clark, anything you want to add on Mr. Kennedy? I'll ask you to chat briefly with Ms. Wood. I recognize it's an old case, and so you might have some trouble tracking down anyone associated on the victim side of things. So if we can't sort it out today, I understand that, but we will want to get discovery moving.
Yes, Your Honor. And Ms. Wood did, as she indicated, she did email me concerning the case, and I had reached out to the victims. I'm waiting to hear back, which is why I wasn't able to.
Okay, and that's perfectly understandable. You were thinking probation revocation, and that doesn't necessarily require you to reach out to victims. If you hear back from them and you and Ms. Wood can do something with it today, we will. Otherwise, we will get a scheduling order out and that'll move this along. Thank you. All right, that leaves us, I think, with just Mr. Robinson. The lawyers just went away. there's one of them.
And I'm actually going to ask to be excused. I did file a demand for speedy trial that's on tomorrow's arraignment calendar, and so I was hoping that Ms. Clark would be here, but I have a copy of her.
What's that case?
Deshaun Rivers, 23 SC 1900397. So this is the time case, the last day that jurors are able to.
Oh, I see it. It's in there. Speedy trial. We need a flag to go on.
You just follow it? Well, I was hoping to serve Ms. Clark. I didn't realize she was going to be virtual. So I served Ms.
Serve my colleague.
Yes.
Let her know. All right.
Your Honor, I'm still here.
Merry Christmas.
Yes, Ms. Clark?
I'm still here. I thought I heard my name. Sorry.
Oh, it's just Ms. Feely wanted to hand you the demand for speedy trial in Rivers. He's on tomorrow's arraignment calendar. But I mean, it's in the docket. It's a legit demand for speedy trial. So that's a case that'll need to move at a pretty fast clip.
Okay, I will have my legal assistant come down to pick it up, Your Honor.
Well, your legal assistant, Mr. Hiles, is right here. He can get it to you.
Okay, all right. Thank you.
But I do want to, since it was served today, I would like to note, I don't think there's going to be jurors for the rest of the year. And so for the term that is in panel, there has to be jurors there. So it's my position that since jurors aren't in panel until the next year, the effective first term would be filed. Would be the first term.
Okay, I don't know the answer to that. I do think that we only had jurors today and yesterday, not tomorrow. So there were jurors here today, noon, but we'll work through that. I'm looking at the charges too. If we need to try it, it looks like it'll take about a day. So it's very doable, and it would give some lucky line ADA whose last name doesn't start with Clark apparently to have a trial in late January or early February. Yes.
The issue is that you are on probation for this
So,
stuff.
all right. Let's turn to Mr. Robinson.
They want to bring up all of this and they want you to do, there's like 11 years left. So unless you're willing to proffer into like a closed court or deal where you go on the stand and proffer against the other people that are shooting, he's gonna ask for all of this. Do you want to do that? Proffer?
What?
I know. Yeah, they're gonna indict him though. I know.
If I'm not done with jail, start charging for it.
The issue is that
You say if you didn't,
no, it's still undone. For that argument, it's just gonna be difficult. But I'm trying to find, he wrote a proffer letter. Willing to proffer, he can do that. Saying that. So.
All right, Ms. Rivers, are you ready?
Yes, ready.
Great. Well, we'll go on the record in 18 SC 160329. It's State versus Jamari Robinson. And for Ms. Rivers' assistance, if we could have appearances for both sides representing the state.
Turn on the mic.
Hold on 1 second.
We don't have.
That screen's not working at all?
Uh-uh.
All right, let me see if I can connect it. And then we'll call IT to make it happen. Sometimes we just have to turn it on and off, but let's see.
He was asking if we kicked the cord and unplugged it, but I don't think so.
Oh, no.
What? Yeah, but the thing is, he's going to bring up the video today because he can do that.
If I'm not charged with video, Screen with a desktop on, yeah.
Okay, let me see if now it'll connect.
Says connected. Has someone's face on it.
Good looking face. Wait, is that George Clooney? No, better.
Judge not.
Yeah, is that your first baby or second?
First baby.
He's only your first. He seems.
It's I like the screens when we're coming in. Before.
Yeah. Try one more time, and then I'm gonna ask Ms. Nelson to, oh, here we go. Let's see.
It's starting. There we go. Good.
All right. Hey, Mr. Robinson, is the screen working now?
Yes, sir.
Excellent. All right, let's try again. If we could have appearance for the state.
For the state is ADA Reeves Hiles.
All right, and on behalf of Mr. Robinson.
Judge Sidney Gibson.
All right, Ms. Gibson, thank you for being here. Mr. Robinson, I'm Judge McBurney. I don't know that we've met before. Your case was resolved by a different judge. I am here because the case is now mine. Either you dealt with your case in front of Judge Downs or in front of Judge Reeder. Reeder, okay. I inherited Judge Reeder's caseload. And so you either went to trial, had a plea in front of Judge Reeder, got put on probation, and while you were on probation, the state alleges, and this petition to revoke your probation actually didn't come from the Department of Community Supervision. It came from the DA's office. Mr. Heil signed it. You were sentenced, as I understand it, to 15 to serve 5 by Judge Reeder, followed by 5 years on probation and a 5-year suspended sentence. So 10 years of time we're working with. One condition was that you were to no longer affiliate with DFW. I'm sure Mr. Hiles is going to tell me what that is. No gang affiliations on social media or otherwise. You were supposed to complete a GED, and you had a curfew for a while, except for school and work. Mr. Hiles alleges that you violated one of these special conditions by associating with a gang known as 952, as well as this gang DFW that you were in particular not supposed to associate with. And Mr. Hiles said that the petition says that this happened in May of this year. Additionally, on that same day, you committed new offenses, it's alleged: aggravated assault, a gang violation, having a gun, and being a felon possessing a gun. And this is allegedly all on surveillance. I'm much more focused on that second part, that you had a gun, allegedly, and that maybe you pointed the gun at people or fired the gun. That would be the aggravated assault. The state has the burden of proof. They have to prove these violations by a preponderance. That's a different burden than at trial. It's a lesser burden. Ms. Gibson is your lawyer. She's had an opportunity to look at these videos and get up to speed with what the state thinks its evidence is. And so the first thing I'm going to do is ask Ms. Gibson whether you, Mr. Robinson, are admitting to these allegations or if you are contesting them. In other words, you disagree with what the state says you did.
Judge, can I have one moment with?
Please.
Be hard to fight that you're moving in a direction where people are, and it's absolutely impossible to fight that you're not in your position.
If I admit.
It's gonna be indicted anyways. Don't worry.
It's going to be. It's no states. I'm just not indicted.
Like, here's the thing: if we contest the charges, we could have a hearing about it today. I understand.
Okay, I'm contest.
You want to contest?
Because due to the fact that it's dismissed.
But that's not the thing. It's is dismissed right now. There are still charges. There are still accusations that are not dismissed. The state is not dismissing the accusations. They're still there.
Okay, so I'm contest.
You're gonna contest that you had a gun in video. That you're on video with a gun.
I can show the video.
Yes. That's what I'm saying. The judge is going to see that video. I don't think that's a good idea. No, I'm telling you, admitting to everything is you admitting to. You don't have to admit this part, but we do have to admit. Contest this part.
The whole not gonna get dropped today.
Right, it's not gonna get dropped, period.
It's not.
Even the possessing a gun.
All right, so I'll ask you, Ms. Gibson, if you've had enough time, whether Mr. Robinson is admitting to the allegations or contesting them.
Mr. Robinson would like to contest these violations.
Okay, and all that means, Mr. Robinson, is that you're putting the state to its burden. They got to prove it. You are always presumed innocent. So, Mr. Hiles, I'm going to turn to you and ask you how you want to move forward. And Ms. Gibson, I should share with you, Mr. Hiles came by, I think it was yesterday, to say because the videos work better on the DA's machine than this nice setup we have here, which was a disaster in a trial that Mr. Hiles had last week, that I may need to move around, which I'm fine to do, and we'll work with the deputies. We may need to move Mr. Robinson so that maybe he's sitting at the prosecution table. You might be in the jury box, whatever is easiest for the four of us to see what's on the screen. I'll need to see it because it's the proof the state wants to offer. You need to see it so that you can argue that it doesn't show anything at all. And Mr. Robinson, obviously, to help you understand what's in it, if he understands what's in it. So I'm fine having us sit wherever. If you, Mr. Hiles and Ms. Gibson had talked about how you wanted this staked out.
I did, well, sort of. Do you know, with Ms. Gibson, I thought it said she might want to move forward in a different manner. Or is
okay
what she said earlier? I don't want to. We're certainly ready to go if that's what you want to do right now.
I think we are ready to go. Game plan has changed.
Okay.
Yeah.
Cool. Then I would. I've got two witnesses. One's here just to authenticate the video or some of the video, and then the other is one of the gang investigators.
Okay. So are you planning on, let me look back at the petition. So you didn't allege anything about curfew or GED. Your focus is one, new crimes, and then two, a violation of the special condition of affiliating with gangs.
Yes.
Okay.
Judge, can I have a moment to speak with ADA Hiles?
Yeah. And then I want us to dive into it.
Yes, of course.
Oh, yeah.
No, it's not. You get drunk. And you don't want to blow smoke up the judge or his ass because they're gonna get pissed off. Like you gotta be straight up, you gotta make a decision, and I know it's hard. What do you mean? Would be after you verified everything. Offer, you can tell them what went on, and they will not cut you a deal.
So I'm crazy. I'm crazy.
Probably for a little bit.
I'm not going crazy. It's a kid. I'm still.
Don't stop.
I'm saying I'm not going to too much happened when I went down the first time. I'm not going to be.
So do you want them to have to prove the charges today?
Hmm.
You wanna go forward with hearing today? Where we go?
First they can.
You're gonna get a possession of the gun charge. Worse, they can have.
Hey, Ms. Gibson, I forgot to mention this. You should mute that microphone right there while you two are talking. When we're talking to get stuff on the record, you had it for a minute. It was red.
I know, it went off
There-
and then it keeps
Look
coming
at
back
that.
on.
All right, well, let me try muting it from here.
Just broken.
You good?
It's weird. I can't mute it from here either. It's unmutable. But I'd like it to be connected. Oh, he did it. He's got the lack of blood in his fingers. All right.
It's my heart.
Judge.
Yes, ma'am.
We are going to admit to the possession of a weapon charge, but would contest the other violations.
Okay. That helps focus things. I appreciate that. And in terms of proceeding, it's still Mr. Heil should call whatever witnesses he wants. He can streamline. You don't need to omit it. You're not forced to stipulate to it the evidence about possessing a weapon. But there's an aggravated assault allegation. So it sounds like there was a deployment allegedly of a weapon. And we'll work through that.
Sorry, Ms. Gibson, do you want, I've got one of the officers pulled the videos. Do you want to stipulate to the video evidence its authenticity, or do you want him to testify?
No, we don't need to stipulate to the authenticity of the videos.
Okay.
You don't want,
Or we will.
you will stipulate. Okay.
Okay.
Like
So-
foundation, that's-
Got it. So you can tender the videos when you're ready to do that. And that won't require a foundation from the officer who obtained them. I'm a little in the dark. I don't know if it's surveillance video or someone was doing this while it was going on or.
Surveillance video.
Okay.
From multiple angles.
Okay, so you can get that in when it's time to press play. But I guess it sounds like there's still another witness you need to call. I don't know if you want to do that before you play these things or not, but it's now 1:48, so let's get going.
Yeah, let's do it. I'll Investigator T, thank you for coming. They're gonna stipulate to, but I really appreciate you being here.
Thank you, sir.
And in your honor, as we were talking about before, I think it would be easiest if you could come around here and we could position this. And that way, when I'm questioning our witness, he can narrate what's going on in videos.
Okay, so where's your witness? Your witness will stand in, I don't mean where is he physically, but he'll stand in front of the screen?
I will stand in front of the screen and ask questions, and maybe he could sit here, so there's.
Just needs to be near a microphone so that Ms. Rivers can see him and see what he's saying and hear him. But then when you figure out where Mr. Robinson is going to be, he may not want to sit right next to the witness.
It's over there.
He might be able to sit there if I can.
You can rotate. That's your monitor. You can have it face any way you want. Don't worry about where I'm going to sit. Get it set up so Mr. Robinson can see and your witness can see, and then I'll pick a spot.
Can you see this? Or if do I need to move?
Can you move that box, yeah, so that we can see the full screen? Yeah.
All right, so if you two can see, then you're good. And the witness will be basically at the state's table. You will be loud wherever you are in doing what you need to do. And I'll just come around and figure out where I'm going to sit.
Yeah.
It's like a field trip.
It's two people.
All right, so that's the witness. We want that spotlighted so Ms. Rivers can see. And I will come on out there.
State that are violating your probation.
Yeah, plenty as it is. I'm saying, but I was not yet. That's my mom, boyfriend. Studio. I work there. So everything you feel. That's my job. That's what I do on my own time. Engineer. At night I went to school for it, got the trade and everything.
You're a rapper.
No, I'm an engineer, but I mean, yeah, I record. So that's what I was doing. That's my job. I didn't come in there and become shooting first. I didn't know you shoot.
The problem is that you had the gun in the second shooting. There was that first shooting that you were involved in. And I get it, okay. This one, there was a shooting before this one outside.
I wasn't involved in
I know, that's what I'm saying, is you weren't involved, so that doesn't help this thing you get now.
Yeah, I was scared. I was scared. I picked up the first one in the summer.
Yeah.
It's no back on in the studio.
Did you pick it up in the studio?
Yes, I picked it up in the studio.
Okay.
I had
The
made
issue
it.
too is that you were not contesting that. We admitted you having possession of it. Our big being that you didn't know these other guys were gang members, and that's what we're gonna have to come.
They booked the session. That's my studio every day. That's why I record anybody who come in. So I didn't know what was coming in.
We'll see how it goes. I don't like to be the bearer of this.
Go sit in the jury box?
I got waiting praise and I'm not going. I'm gonna kill myself before I go. I'm not going to text. I'm not going. I got raped.
So that testimony you'll be able to truth, the whole truth, nothing but the truth, so help you God.
I do.
Lord, and state his presence and the record.
Detective Brandon Pectel, BRANDON PECTOL.
All right. Good afternoon, Detective Pectel.
Good afternoon.
Where are you currently employed?
Atlanta Police Department Gangs Unit.
How long have you been employed there?
Since February of this year.
Okay. Is that how long you've been at City of Atlanta?
No, since May 2016, I've been at City of Atlanta.
Okay. And you've been in the gangs division?
Since February of this year, correct.
What are your duties in the gangs division?
Duties are going to range from investigating gang crimes, investigating trends of gangs, identifying gang members, and associations, investigating new developing gangs, and progression of already established gangs.
Okay. And do you have any specific training in investigating gangs?
I do. I've got currently 13 hours of gangs training to my record, but I've got experience over the years of dealing with gang members through my work through the City of Atlanta and different patrol functions, as well as my other coworkers are different gang experts, so I'm able to verify with them. They aid me in investigations whenever I need help.
Okay. I'm going to turn your attention to May 22nd of 2023. Did you become involved in investigating the homicide of Dominique McKibbins?
I did.
Okay. And how did you become involved in that investigation?
So on May 22nd, we had a arrest that was made of another gang member. During the interview, he brought up Mr. McKibbins and his associations. Afterwards, after the interview, I spoke with different supervisors from different investigative units, homicide, aggravated assault, therefore. And later that evening, I was called, disconnected. I gotta go back to the bench. Reconnect them. Can you unlock this door? Thanks. Move around. We're gonna leave your monitor off for now. Your microphone is still working. Ms. Rivers, can you hear Detective Pectel? Can you hear me? Ms. Rivers, can you hear the detective when he talks? Check, check. She's still muted.
Ms. Rivers?
Yes, I can hear.
Okay, great. We're all going to be viewing what's on that big screen, which isn't going to travel through the Zoom system anyway. So absolutely, this is a problem in here and only in here. We're working on it. All right.
Okay.
Shall we continue?
Yeah.
Okay.
So, were you assigned to investigate the gang aspect of the homicide of Dominique McKibbins?
I was.
Okay. And when you were assigned to investigate gang aspects of crimes, are you actually assigned to the underlying crime?
No, I'd be assisting the lead detective in whatever capacity that they need.
Okay.
My function being brought up to the gangs unit is to work complex cases due to my experience on aggravated assault.
So I will be assisting in any capacity that the lead detective would need for the primary investigation, but also have my role in investigating the gangs aspect of things.
Okay, and are you familiar with 2555 Donald Lee Hollowell Parkway?
I am.
Okay, and what is the significance of that address?
That is where the incident took place. It is a music studio currently. It's got a string of businesses. It's been a number of things over the years in that string of businesses.
The 22.
2555 Donald Lee Hollowell Parkway. What county is that in?
That is in Fulton County.
Okay. And was this particular incident, was it caught on video?
It was.
Okay. And were you able to review the video to try and identify the individuals involved in this homicide?
Numerous times.
Okay. How much video did you review?
Hours worth of footage.
Okay. Your Honor, I've got State's Exhibit 1, 2, and 3 on a flash drive. State's Exhibit 1 is video from 2560 Donald Lee Hollowell. Exhibit number 2 is video from the poll camera at 2555 Donald Lee Hollowell. And exhibit number 3 is video from 2555 Donald Lee Hollowell. This time, based off stipulation, the state would move those 3 exhibits into evidence.
The third is the same address as the second, but it's not poll cam, it's surveillance video.
Yes, the poll camera is the city of Atlanta on the telephone poles.
Whereas the exhibit 3 would be surveillance devices installed at 2555.
That's correct.
Okay.
All right, and there are, as everyone can see, numerous videos in each exhibit. I have taken the videos that I intend to play and loaded them on the computer, so that way there's no lag between communication.
Okay. So before you go any further, Ms. Gibson, any objection to the admission of State's Exhibits 1, 2, and 3 for the purposes of this hearing?
No objection.
Okay, they're admitted.
The last note I will make for the record is that on the flash drive, there is a 4th file that is labeled videos played in court. And that is the specific videos that I put in a separate file that will be copies. So that way there's no confusion.
Okay. But those files that are in the folder videos played for court come from either Exhibit 1 or 2 or 3?
Yes, I think they're all gonna just come from exhibit. They'll come from exhibits 2 and 3.
So we won't be seeing anything in here unless cross-examination leads to it of video from 2560 Donald Lee Hollowell.
Yes, that's actually from across the street, so it's good. Okay. Okay. Detective Peckel, will you tell the court and everybody what's currently going on in this particular?
So right here is about an hour and a half prior to the homicide taking place. As we see on the camera, we have a group of individuals hanging out in front of the music studio. They were recording inside at the time. We have members of Famerica 952 present.
You said you have members of Famerica. What is Famerica?
Famerica is a criminal street gang.
Yeah.
Is that basically the word America with an F in front of it?
Correct.
And when was that gang founded?
So Famerica started as a Deadly Killer Click. And Deadly Killer Click then started recruiting and had younger members that identified as Young Killer Click and then Lady Killer Click. And they started considering themselves a family. As their recruiting expanded through the early 2000s, they reached out to Crips from Thomasville, which was Young Gunner Click, and recruited them into their gang. At that time, they took on the flag symbol using white as the neutral color, blue to represent the Crips, and red to represent the Bloods, and they came up with the moniker and name Famerica.
What is, I didn't name a lot, did you say anything about YKC or Young Killer Click?
I did.
Okay, what is Young Killer Click?
Young Killer Click was a subset of Deadly Killer Click that was the younger members.
And as it sits today, has Famerica rebranded?
They have.
Okay, and what is their rebrand?
Their rebrand currently is the name 952.
Okay, and the numerals 952, what is that? What's the significance of that?
952 is, if we look at our phone keypad, it is 9 is Y, 5 is K, and 2 is C. So it represents YKC, Young Killer Click.
All right. Before so were there multiple shootings during this hour-and-a-half period?
There were.
Okay. So I'm going to.
Is the timestamp more or less correct? Is it about 10 p.m. or
So,
from what you understand, is it 2 in the morning and we should do some math?
There is a difference in time. I believe it's about 21 minutes. And the video footage is going to be represented 21 minutes ahead. So this is actually going to be 9:48 around in the evening time.
It's close enough. It's not the wrong day.
Yeah, it's not the wrong
12
day.
hours up.
It isn't.
Okay. Okay. What's going on? Individuals, fast forwarded to where it says on the screen 10/12/05. The individuals who have just gotten out of that car, do you know who they are?
I do.
Who are they?
So the individual that is looking straight ahead with the black and white sweatshirt, that is our decedent, Dominique McKibbins. Also looking into the vehicle on the passenger side right now with the skull cap on, is going to be Benjamin Ware.
And are they associated with any criminal street gang?
They are.
What criminal street gang would that be?
That would be DFW, down for whatever.
Okay. Play again. And do you see anything in Dominic McKibben's hands?
At this time, yes. He has got his a gun in his left hand right now. You see the laser that's pointing on the ground. Now it's moved to his right hand.
And at this point, is Dominique in a dispute with anybody else that's at this location?
Yes. So this is this incident has been leading up to for about 2 weeks. There had been a dispute regarding the theft of a firearm, where Mr. McKibbins and the individual that had walked previously out of camera view with the Draco in his waistband, that is Mr. Nitavius Davis, have been going back on social media, on Instagram, regarding trying to get back this said firearm that Dominique possessed.
Okay. And is that the one with the green laser that you can see?
That is correct.
So I want to make sure I follow. Your theory is, or what you uncovered through your investigation is that the gun that Mr. McKibbins had, someone felt was stolen from him, not meaning Mr. McKibbins, but in other words, Mr. McKibbins was walking around with someone else's property.
Correct,
And that has upset that someone else.
correct.
And is that someone else the guy with the Drago in his
So
waistband?
no, Nitavius Davis, who is right here on the right with the Draco in his waistband, was actually tasked with getting the firearm back from Mr. McKibbins. So there will be 2 weeks of conversation back and forth with them on Instagram regarding getting this firearm back.
The guy with the white pants with the gun that you can see, I can see, his role is gun collection.
Correct.
From Mr. McKibbins.
Correct, Your Honor.
And is it your theory that Mr. McKibbins is aware that he's showing up to return this gun?
So
Or is it gonna be news to him that he has to hand it over?
So the theory behind this is that the firearm at this point was never going to be given back over. And while Mr. McKibbins and Nitavius Davis do have a history between each other on a positive end, this 2 week of back and forth has led to animosity between Mr. McKibbins and Nitavius Davis and his associated group.
Okay.
And did you get Dominic McKibben's Instagram records as a result of his murder?
We do.
And is that how you were able to determine this ongoing dispute?
That is correct.
So the timestamp is 10/12. I'm gonna go to a different in 1 second, but is there does a shooting happen just out of frame of this incident?
That is correct.
Okay, but and after that shooting, is there a large exodus of individuals from inside the studio?
Yes, there's in and out of the studio. People are running in, people are running out. It is mass confusion at the time.
Let's play through, and then I'm gonna go to the next screen when the shooting occurs. Okay. Were you able to identify the person that I am pointing my finger right next to the Lincoln Navigator?
We were.
Okay, and who was that person?
That's Mr. Jamari Robinson.
Jamaria Robinson?
Jamari Robinson.
Jamari Robinson, okay. And is that the same Jamari Robinson that is in court today?
It is.
Okay. Can you please point out Mr. Robinson by where he's sitting and what he's wearing?
Mr. Robinson's sitting directly to my left in a blue Fulton County jumpsuit with a long sleeve gray undershirt or sweater.
Your Honor, please let the record reflect that the witness has identified the defendant.
So we're clear. I find that Detective Bechtel has identified Mr. Robinson as the guy sitting in court. I don't know yet that he's identified Mr. Robinson as the guy on the screen. I've heard him say those words, but the ID I'm confirming is in court.
Okay. How were you able to identify him on the screen?
So this was a extended process. We were able to get an anonymous tip in that started it, that this individual in particular goes by the name of Mari, and we were provided an Instagram. At that point, I was able to, and a phone number at that time. I was able to locate the Instagram, which on his Instagram at the time, in his description said Mari Robinson. At that time, I then checked the number. The phone number came back to his mother, Miss Robinson. And then I began going through our reporting system to identify any Mari Robinsons at the time, and I was able to locate a Mr. Jamari Robinson, at which time I pulled up a driver's license photo of Mr. Robinson, was able to match it up with the footage that I was observing, as well as the Instagram provided. I then did a CDR search warrant on the phone number provided. And I also did an Instagram search warrant on Mr. Robinson's account. I was able to get the records back for the first phone number first, verifying that that phone number was most likely in Miss Robinson's possession at the time. Subsequently, I was able to get the Instagram return back, at which time I was able to locate another phone number that Mr. Robinson had given out to an individual he was speaking to. I then did another CDR on that phone number, which placed him at the scene during the times of the incident and tracking away from the incident.
And obviously, Mr. Robinson's currently in custody in the courtroom. When he was arrested, did you interview Mr. Robinson?
We did.
Okay. And did he admit to being in possession of a firearm?
He did.
Okay. Did you confront him with screenshots of himself from this video?
We did.
Okay. And did he confirm to you and Detective Fitton that the person on the screen was actually him during your interview?
He did.
Okay. And as you can see what does appear to be in his right hand?
That appears to be a firearm.
Okay. And how long approximately did Jamari stand outside with that firearm?
Between the two shootings, it's about an hour and a half.
Because I want to show you, investigator Becker, we're going to go to the other view.
So, Detective, when you say that Mr. Robinson in his interview with you admitted to being on the scene, in particular, he confirmed that the guy with the white T-shirt and low-riding blue jeans, that's Mr. Robinson.
Correct.
Not just, hey, I was there, guess who I am, but.
No, he confirmed that that individual that I believed was him, was in fact him.
So the camera angle that we're looking at now, is that the same camera, or is it the same location from the previous video we were just?
It is. It's just on the opposite angle.
Okay, I'm gonna hit play. And who is this individual?
That is Nitavius Terrell Davis.
The guy with the big gun in his pants.
That is the same individual with the Draco in his pants. Okay. And this is our decedent, Dominique McKibbins, with that same firearm that was you observed in the previous footage.
So McKibbins shot at the guy with white pants.
Correct.
Did he hit him?
No. So McKibbins was able to discharge his firearm at Mr. Davis. Mr. Davis was able to go around the side of the building and exchange gunfire with him.
So when you saw everyone scatter, was that Nitavius Davis returning fire at this incident?
It's simultaneous.
And so when you look at that timestamp, it's 10/12/39, correct?
Correct.
Okay. And is that after the shooting? Is that when you see Jamari Robinson come out with the pistol in his hand?
That is correct.
And he remains on scene for about an hour and a half, correct?
Correct.
Forward. This is, and is that pointing at Mr.
That is still Mr. Robinson.
Instead of having us all sit here and watch. So what's going on at this point?
At this point, the individuals are trying to figure out what's going on. Some of the individuals that had come out of the studio that were inside at the time are trying to figure out what was going on. And now the individuals that were present outside are discussing on how they're going to address this issue.
Was anyone hit in this initial exchange?
No, so the only thing that happened was one of the rounds that were returned by Nitavius Davis hit this Nissan right here and disabled it. This is the vehicle that Mr. Yes, that Mr. McKibbins had shown up in with his cousin and 2 associates.
I'm going to turn the sound on just for a little bit. It's got a little bit of feedback, so I'm going to turn it back off. But so this video come with sound as well?
It does.
And is it exactly paired up to the video?
It is not.
Take a second. But based off of what you heard, were you able to just hear arguing?
We were able to hear arguing back and forth. We were able to clearly hear some of the statements made by individuals on scene.
So Mr. Robinson is the guy who's showing us his underpants? Right?
Correct.
Okay.
Still has the firearm in his right hand.
Now, what gang were the members in the white car? Who all came in the white car?
Those are members of Born Rich and DFW.
Okay. You say Born Rich and DFW, are those one and the same?
Yes, DFW is a subset of Born Rich.
And how long has that particular gang been in existence?
Born Rich developed in the mid 2000s, and in 2016, younger members of Born Rich created the subset DFW, standing for Down for Whatever.
Is Down for Whatever, are they commonly known amongst the streets of Atlanta as DFW?
That is correct.
Okay. Now, can you tell, for the record, who all was in the white car?
The driver was Torrance McKibbins, the cousin of Dominique McKibbins, also member of Born Rich. You also have Keontae Gerald, who was in the back driver's side seat. You have an individual by the name of DJ that was in the front passenger seat, and Dominique was in the rear passenger seat.
And Keontae Gerald, Dominique McKibbins, and
Torrance
McKibbins. What gang are they part of?
All Born Rich DFW.
DFW?
Correct.
Okay. So at this point, is it fair to say that the groups are separated in DFW and 952?
You'll see throughout the incident that members from both sides do interact with each other, but right now you do have the separation. Except for, I believe, Jarquavius Harris is over there talking to the individuals right now.
Okay. And how many members of 952 did you identify off of this video?
There's a handful of 952 members and from America. Like I said, so we do have the split right now. There is some interaction. You do have two DFW members that are interacting with 952 members right now. And then you have the one America 952 member that is with the DFW members by the car. So you have at least, I believe, 8 or 9 individuals that are identified with 952.
Okay. And just for what you can tell by looking at it now, based on your review previous, can you say the names of the 952 members you've identified that are out there?
I can.
Okay, will you please say this for the record?
You have Jarquavius Harris, which is one of the founders of 952, and also a high-ranking individual in Famerica. You have Jaquan Felts. You have Marcus Foley. You have Lindarius Johnson. You have Quintavious Williams. You have Jamarian Williams. You have present also Brian Bedford at the time in this video.
So this arguing goes on for about a little over an hour?
Yes.
So you didn't mention Mr. Robinson as a member of either gang, is that because, or organization, is that because you don't consider him one, or did I miss you say his name?
So we were just, I believe the question to be other members that were present that I haven't identified yet.
Okay, if you were to place him in one of those two groups, my understanding is it would be 952.
So Mr. Robinson had previously pled to a case where he wasn't, as in his stipulations, not to associate himself with members of DFW. But during this time leading up to this incident, members of DFW and 952 for America had joined up with each other in association for music and criminal activities.
Okay. So did this shooting cause a rift between 952 and DFW?
Absolutely.
Okay. And did you see, so after the shooting or during this incident, did you see some of the DFW members move their association to 952?
Correct.
Okay.
I did.
And what about Jamari Robinson?
Through this incident, you could see that he aligned himself with members of 952.
I'll ask one question on that. I'm gonna fast forward to the 10:44 mark.
So standing now at the rear left corner of the Navigator is the guy who had the big gun in his pants?
That is correct. That is Nitavius Davis.
And where's Mr. McKibbins?
He's leaning on back of the gray sedan parked right next to it.
So two guys who just shot at each other are now just standing there.
Correct.
Within a few feet of each other.
If we watch the completion of the video, only one car fled from the scene, but the passenger of that vehicle that fled came back to the scene. So nobody actually, like the mass of this group, stayed on scene.
Okay. Is it safe to say that over this hour and a half, the tensions consistently built between these two?
Yes, it's like a roller coaster. It escalates and then de-escalates and then escalates and de-escalates.
It looked like Mr. McKibbins fired a bunch of rounds at the guy in white pants. We couldn't see or hear what the guy in white pants did in response. Do you have information from having spoken with people at the scene or audio, whether it was one shot fired back at Mr. McKibbins or a whole bunch?
It was multiple shots through the audio.
Okay. Ms. Gibson, I want to make sure you're able to see Mr. Hiles. We're not watching anything in particular, but he's not blocking your view.
So,
He's not now. He was partially.
Okay.
okay, I'll try to stand where I'm. Does this portion of the video go through about 11 p.m. on?
Yes,
timestamps?
it does.
Then.
So the record is clear, you started playing another video that appears to pick up exactly where the other video left off. You're at 11.
That's, sorry.
Sorry.
I'm gonna fast forward just till after 11:20. I'm gonna let it play through. Right now it's at 11:27:04. And for the record, are both sides now pointing guns at each other?
Correct. You see Mr. Robinson.
Is this Mr. Robinson?
Yes. And this is the final push against our decedent, Mr. McKibbins.
Okay. And is that Mr. Robinson that just raised his firearm?
Yep, and that was him telling some individuals to move out of the way.
It's got a strange color. It looked like it was khaki.
So it does appear that it has probably a silver slide to it.
So at this point, has shooting erupted?
Yes, at this point, shooting has erupted.
And is that, you earlier identified as Mr. Robinson right there?
That is Mr. Robinson.
And can you see Mr. Robinson discharge his weapon at this point?
Yes, he'll go into the rear passenger side and then go behind the car and then just start to discharge his weapon multiple times.
Flash from his.
That is correct.
Can you rewind that?
So is this the push of Mr. McKibbins? Okay, back. So were you, okay.
So
Where's that?
that's Mr. Robinson. He flares out, and then when the shooting starts, he retreats to the vehicle. Goes to the passenger side, opens the door briefly, then goes behind the vehicle, and then starts to discharge the firearm over the car, striking his own car once.
And
you say his own car. Which car are you associated with Mr. Robinson?
This is going to be a Jeep Compass that is right behind it. He stated in his interview that he shot his own car.
Okay. All right. So, and did you notate that cars passing by as the shooting interrupted?
Yes.
Okay. I'm going to switch to the other angle so we can see the same thing.
Here's the push.
Is that Mr. McKibbins?
That is Mr. McKibbins.
Are there two people lying down? It's at a
Yes,
weird angle for me.
there is two people. So there is another individual that was shot during this incident. That's going to be Contavious Williams.
That's the guy in orange or red?
Yes,
And the other is the guy who's not moving is Mr. McKibbins?
that is correct.
Okay.
And so, based off the last frame, when we saw, you identified Jamari Robinson as discharging his firearm, would that have been in the direction over there, across the hot?
That's going to be in the direction of the street and exit to the parking lot right here.
Now, which way did the members of DFW flee?
You had Torrance McKibbins that fled straight ahead. You saw him actually come back into frame with the light on his firearm, discharging rounds. You'd seen Cameron Kindred flee across the street. Cameron Kindred is a member of DFW that sided with 952. You see Keontae Gerald flee across the street, and that is a member of DFW as well. Cameron Kindred and Keontae Gerald end up exchanging gunfire across the street. Nitavius Davis shoots at Keontae Gerald while he's crossing the street, and Xavion Dillard, who is an associate of 952, discharges rounds at Mr. Gerald running across the street.
Is it safe to say that you, at this point, had, after Mr. McKibbins was shot and killed, you had an exchange of gunfire between DFW and 952?
That is correct.
Okay. Now, since this incident occurred, have you seen this rift between 952 and DFW continue?
Yes, it started a gang war.
Have you had retaliatory shootings?
Yes, there has been. There has been another associated homicide with the mother of a DFW member getting killed and the house getting shot up. We have multiple Instagram posts being shown that there is a ongoing feud between 952 DFW. We've made arrests that have confirmed that there is a ongoing beef between the two groups.
Okay. Now, what sort of crimes are DFW known to commit?
DFW started with entering autos and auto thefts. They started with Dodge products, Mopar products, then escalated to high-end vehicles, luxury cars, luxury sport cars. They also developed into committing armed robberies and carjackings, aggravated assaults, all the way up to murder.
Okay. 952, what type of crimes they known to commit?
952 for America was predominantly known for narcotic sales, but they have engaged in armed robberies, aggravated assaults, and murder. They do engage in some auto crimes, but their basis is narcotics related offenses.
I don't have any further questions at this moment.
All right. Ms. Gibson, do you have questions for Detective Peck?
I do.
I'm gonna stay right here if that's all right. Well, are you gonna, Mr. Hiles, do you have other video you're gonna show? I think this is your one witness.
Yeah, it's my one witness. If you want to come up here, I can sit down, or if you want to sit there, I'll remain here.
Well, my next question was for Ms. Gibson. Are you gonna use the video at all? So if you're not, I wanna go back to my desk. If you are, I'm fine staying right here.
I don't plan to, as long as Detective Pechtel has some idea of the questions I'm gonna ask, you know, the framework of the screens that ABA Hiles just looked at.
I'll wait here
Some
because he may
remembrance.
need to rewind to get it set up, so I'll just stay right here and you ask all the questions you want.
Okay, if I need you to rewind.
I will do it for
to a
you.
certain time,
Absolutely.
That just you're better.
Can you make sure your microphone is unmuted? If it hopefully will now.
My
be
screen also did go off again,
muted. Okay. You
but
don't need that.
I
We
don't
just-
need it.
yep.
I just wanted to,
Sure, thank you.
okay, Detective Pechtel. At the beginning of the incident, where was the entire incident? Where was Mr. Robinson?
Are you referring to the first shooting or the second shooting?
The first.
The first shooting, Mr. Robinson was inside the music studio at the time.
And are you aware of Mr. Robinson's job with that music studio?
I'm unaware of his job with the music studio.
Okay. When you mentioned the guy with the Draco, which I assume is the big gun in his waistband.
That is correct.
Is Mr. Robinson anywhere around at that point?
No, he's still inside the studio.
And you on direct said that after the first shooting, people then exit the studio and there is, quote, mass confusion.
Yes, so there's, as we saw previously, that individuals ran into the studio and individuals came out of the studio.
And was Mr. Robinson one of the people involved in that mass confusion exodus from the studio?
The individuals that came out of the studio, Mr. Robinson was one of those individuals.
At the end, when the video shows Mr. Robinson going toward the SUV type vehicle by the road, is there a clear view of who is shooting above the vehicle?
There is not a clear view of who's shooting over the vehicle.
And you testified that the shots went toward the road, not toward the group, toward the exit entrance to that parking lot.
As we saw in the video, individuals began fleeing the parking lot across the street. You had two individuals that fled, and then individuals that scattered throughout the parking lot towards the sidewalk and everything like that. So that would have been the angle in which that car was aligned, and where individuals were running to.
Was the weapon in Mr. Robinson's hand ever recovered?
No, it was not.
Do you have any indication of what type of weapon that was?
It was a handgun. It was a pistol.
Any specifics that would enable you to match bullets that were shot to the weapon in his hand?
Well, like I said, there was no firearm recovered, so there will be not, unless it was used in another crime, there would be no way to match the ballistics.
So there's no indication that that weapon was used in any other crime because it was not recovered as well?
Because it was not recovered.
No further questions at this time.
All right. Do you have any redirect?
Briefly.
While you're pulling that up, Detective Pector, you've testified already that Mr. Robinson gave a statement after he was arrested and acknowledged that he was at this scene and he was that person, white t-shirt, blue jeans, and that he had a gun. Did he take it one step further and acknowledge that he was discharging the gun during the little snippet where you're saying he was discharging the gun?
Yes, as I previously testified, he did admit to discharging the firearm and shooting his own car.
Oh, that's right. You did. You did. Okay. All right. Thank you.
Is this Mr. Robinson?
It is Mr. Robinson.
And do you have a clear view of where he is just prior to the shooting?
I do.
Okay. And can you clearly track Mr. Robinson as he moves?
He's been good.
That's presumably the same Draco that Mr. Nitavius Davis had previously. But yes, we can track Mr. Robinson on all his movements.
And can you see what appears to be muzzle flash?
You can see the muzzle flash as well as the gas dispersing from the weapon.
And what is muzzle flash?
Muzzle flash is the ignition of the gunpowder when a round is discharged, and it would be the explosion coming out of the barrel of the firearm.
Can you rewind and show me? I keep watching the Ultima get shot up and I'm noticing that. So if you rewind a little bit, I need to be looking in a different place. So allegedly there's a Jeep Compass way in the back there.
Yes, so
And you're
right there.
saying that Mr. Robinson is there. And if I focus on that Jeep Compass, I'll see what looks like muzzle flash.
Muzzle flash and the gas being dispersed from the firearm.
I will follow him. That's all right.
Now you should be able to see when the round actually strikes the vehicle as well.
Is he the one who hits the Ultima?
No,
Oh, when he hits his
when
own
he hits
car.
his own car,
So he's now off screen.
he's gonna start retreating.
Yep. In-
Okay. That's all that I have.
All right. Do you have any other witnesses?
No, Your Honor.
All right. Ms. Gibson, are you gonna call any witnesses?
Cross-examine anything you say, and he's gonna get you to say whatever. I would advise that you not.
Judge, is it possible that I can call, if she's willing, Miss Robinson, just for a
Call any
brief,
witness you want.
a
to
brief
call.
question?
Sure, why don't you check with her? I'm gonna migrate, unless you're gonna use the videos
No,
with Ms. Robinson. I'm
Not
gonna
using the
migrate
video at all.
Back to the bench.
I'm gonna move this out the way. Great witness stand.
May I be excused?
Um,
Your Honor, may I be excused?
I'm done. I'll let Mr. Hiles decide whether you're free to go, but I appreciate your testimony.
Thank you very much.
She's going to testify.
Is she gonna sit in the witness stand?
She'll be, yeah,
We wanna move, yeah, I was just
We
saying
will.
that box.
Yep. And let me do one other thing before you swear her in, please. Let's do this. Nope. Okay.
Raise right hand. Right hand. Do you swear or affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Hello, man. State and spell your name for the record.
Sharika Robinson, SHIRIKAROBINSON.
And Ms. Robinson, I want to welcome you to the courtroom. I need you to move a little closer to the microphone and use your best outside voice, because our court reporter needs to be able to take down what you say, okay?
Okay.
Thank you.
Ms. Robinson, I just have one question for you. You were in the courtroom witnessing the videos of the incident, correct?
Yes,
And whose studio is that in the incident?
my boyfriend.
Thank you. No further questions.
Ms. Robinson, your connection to the Mr. Robinson who's here in court, is that's your son?
Yes, sir.
Okay. And your boyfriend who has the studio, what's his name?
Denzel.
Can you say that again?
Denzel.
Denzel. Okay. Does he have a last name?
Cuffy.
Cuffy. All right. And how long has he been your boyfriend?
For about 4 or 5 years.
All right. Mr. Hiles, do you have any questions for Ms. Robinson?
I do not.
All right. Thank you so much, ma'am. Anything else, Ms. Gibson?
Nothing further, Judge.
Okay. Any rebuttal?
No, Your Honor.
Nope. All right, then the evidence is closed. And I'm happy to hear argument, Mr. Hiles, from you as to why you think you've demonstrated by a preponderance that Mr. Robinson violated one or more of the conditions of his probation. I'll let you know so you don't have to spend a lot of time on it, either of you. I do find that the state has shown by a preponderance that Mr. Robinson possessed a firearm, discharged that firearm in the direction of others, so aggravated assault, and don't remember what else was charged, but he was either a first offender probationer or a felon at the time he had the firearm. So certain boxes the state has checked. We're not in a position of no violations. If you want to focus on whether Mr. Robinson was actively consorting with gang members or he was present with them, but he was there more so because his mom's boyfriend has a studio and he was working there, we can focus on that. But the, to me, more serious and life endangering aspects of the petition have already been demonstrated. And I just say that so you don't need to spend a lot of time arguing it, but I want to hear you, and then I certainly want to hear from you, Ms. Gibson. Okay?
Yeah, so I think based off of what you saw on the video demonstrated that he was, even if it was his mother's boyfriend's studio, he clearly knew the other individuals. They felt comfortable enough for him to stand around with them, talk with them while he had a firearm displayed for, if you watch the entirety of the video, over an hour. This isn't an issue of self-defense where he got scared and picked up a firearm to return fire. He might have been startled after that first incident, but definitely doesn't give him the ability to stay around for over an hour with a firearm displayed and act as a security guard of sort. Additionally, what you did hear from Detective Pechtel is that Mr. Robinson then aligned himself with the 952 members after this fracture and shot in the direction that the DFW members were fleeing on the screen. So at a minimum, he was associating with 952 by his mere, by being present and hanging out with a firearm for an hour, and then picking one side, shooting at what turned out to be a rival, I would say would be in furtherance of the 952 group. So I do think the state has proved by a preponderance of the evidence, at least, which is our burden of proof, that he engaged in participation in criminal street gang activity. And I will leave it at that. I want to point out too that the severity of this incident, not only could more people have been killed, but there was consistently cars driving down Donald Lee Hollowell. It wasn't even midnight, and that the shootout occurred over the highway where innocent passerbys could have been hit. So I would stand on the testimony, my argument, and ask that you revoke not only the balance of his probation, but also the consecutive suspended sentence.
All right. Let me see if Ms. Tucson, I think you shared with us already on the calendar. Mr. Robinson, it looks like, has just under 4 years remaining on the probated part of his sentence. Is that correct?
That's correct.
Okay, thank you.
Okay,
And he had one earlier revocation. Does your system tell you for what?
Sure, give me one moment.
Okay.
Pull it right up. Jamari documents. This was in 2019, and all it states is it's just a revocation order. It just states that this person was it was a written order, so it's kind of old. This person was before the court probation revocation, and it was signed, and that was it. And he had to report 48 hours after release.
Got it. Okay. Appreciate it. Ms. Gibson,
I can look at
thoughts.
the warrant if you want, what the warrant was for.
Okay. If you can find it.
I can find it. It's right here.
Okay.
It just states here that he violated probation on or about 11/20/2027, committed new offense of theft.
What was that year?
Yeah. I
Sounded
heard-
like she said 2027 and that.
Did 2027. 2017.
Thanks for clearing that up. That would be kind of scary to be predicting Mr. Robinson's future. Okay.
I don't think he was sentenced in this case till 2019.
He was on for first offender for a previous.
Oh, okay. I understand now.
This is just a prior revocation in another matter.
Okay.
Yeah.
Okay. Thank you for clearing that up. Ms. Gibson, I'm interested in hearing your thoughts.
Judge, well, I know that the video shows Mr. Robinson's possession of a firearm and his discharge. I would argue that with the footage shown, it's difficult to tell with how many people ran behind that Jeep. Who is behind there? Who is discharging what weapon? There was no weapon recovered. While we do see a weapon in Mr. Robinson's hand, we don't see clearly who is behind that vehicle firing toward the parking lot area. There is no weapon recovered. Therefore, no bullets recovered that connect to that weapon because there's no weapon recovered. Mr. Robinson was in the studio at the time of this entire incident coming to be. He did not invite these people. He was doing his job as a sound tech engineer for his mom, Mr. Cuffey's boyfriend, of whom he's worked at that studio for various years. There's no indication that he was working there in affiliation, regardless of who uses that studio. There was no testimony or evidence that the reason he was there was for this incident. The only reason he was there is he came outside hearing shots, as I imagine a lot of people would do. I know I'm not going to stay inside and wonder what's going on when I hear a lot of commotion. So he came outside. There's the verbiage used that he aligned himself with one of these sides, but I don't believe that his mere presence on one side or the other. I think his presence toward the far side of the parking lot doesn't align him with either of these groups. It simply shows that he was smart enough not to go where the major gunfire was happening, toward the left side of the screen where someone ended up dying. I wouldn't call that an alignment. I would call that a smart move for his own safety. I would argue that, one, the case that these charges fall under is currently in a dismissal for want of prosecution state. It has not been indicted. And so
You're talking, just so I follow, not meaning the case for which your client is on probation, but
Right.
whatever happened on May 22.
Yes, that case is currently in a dismissal for want of prosecution status. The only open case against Mr. Robinson is a theft by taking. And I'm unsure of when that occurred. But I would argue that the state's request to revoke him in full, even the consecutive suspended 5 years, is excessive considering Mr. Robinson's, I wouldn't say lack of involvement, but for lack of a better word, his lack of involvement in this scenario as a whole. He's pretty far removed from all that happened other than standing around with a weapon, which I would argue is a self-defense move considering what was going on outside of this studio. I would argue that his probation should not be revoked at this time. And he has a baby being born in about, what day is today? The 19th, in 7 days. And that his mom, who is here today, is going through chemo. His little sister is also here today. He has a family that in the meantime, while the state works on indicting this case, that he could spend time with. And so I would ask that Your Honor not revoke his probation at this time.
All right. Well, thank you. And Mr. Robinson, I'm sorry for what your family's going through on the sad side, your mother not being well, but getting treatment. I'm excited for you that you've got a little kid coming. Is that your first child?
Yes, it's a boy.
It's a boy. Okay. Well, congratulations on that. I do find that you violated the terms and conditions of your probation and the law, although I'm only finding this by preponderance. So we'll see what happens with charges that would flow from what happened on May 22. But it is pretty clear that you had a gun, you admitted to it, you fired it, you admitted to it. It doesn't seem like any of your shots hit anyone, but that's not really the point here. And that's why there's not an allegation of murder. I'll tell you what was most eye-opening to me was how quickly almost everyone on the screen was able to pull a gun out of his or her pocket when it was gun time. Everyone. And it is amazing that only one person died and one other person was hit. People had real bad aim because there were bullets going in all sorts of directions. All of that was totally inconsistent with the terms and conditions of your probation. So I am going to revoke. I need to talk with Ms. Tucson about how I structure it. So I will enter an actual order so you'll know what exactly happened, but do know that I am revoking your probation. I just don't know exactly how to structure it yet, technically. So I'm going to talk with Ms. Tucson and my litigation manager, and then I will enter a revocation order. Once that's entered, you and Ms. Gibson can decide whether you think there's a basis to appeal it because there wasn't evidence behind it or the sentence is illegal or whatnot. And in the meantime, the state is going to figure out what it's going to do with new charges, if any. But I want to bring closure to what's going on with your case. It merits mention for the record that the case you pled guilty to, for which you are on probation, also involved allegations of gang activity. So it's not like we are for the first time ever confronting you allegedly being mixed up with folks who are making life complicated for a lot of people. So I will take under advisement the sentencing piece because I don't know the logistics of it, but I do find that the state has proven by a preponderance of the evidence that you violated at a minimum the condition of your probation that you not break the law. And I find that you did violate the law that prohibits you from having a gun, being a convicted felon, as well as aggravated assault and possession of a firearm during the commission of a felony, those three. And that's more than enough for me to think we need to have that have some consequences for you. So that's where I am. Mr. Hiles, do you have any questions?
Yeah, so I just want to, I was a little confused too, on the sentencing sheet for the case we're here, the 18 SC 160329. What it says in the actual, I guess, columns is not in line with what it says in the final disposition. So almost all counts are concurrent, but when you get to,
so I'm looking it up. Just give me 1 second. So I'm looking at the same thing. All right. So it's 10 to serve 5 on all the counts on the first page. Oof, then it goes all over the place. But everything is concurrent with count 1. Holy moly. This was a long indictment.
then if you get to Count 50.
Okay. Yep.
You got suspended to consecutive to count 1.
Right. So there's your 15 to serve 5.
Yes. So, but when you get to sentence summary, it says the defendant's below, outside the sentence summary, the defendant is sentenced to a total of 15 years with the first 5 years to be served in confinement, followed by 10 years on probation.
Right. That is a mistaken sentence summary.
Yeah.
The sentence is as you put it in your petition, and as I think Ms. Gibson understood it, which is 5 years to serve, and Mr. Gibson's completed that, followed by 5 years on probation and 5 years suspended. And that suspended part is count 50, which was possession of a firearm during commission of a felony, which was consecutive to count 1 suspended. I think there are other errors in the I think all the possession of the firearm should be running concurrent with each other, but consecutive to count 1, but we don't need to tangle with that. It doesn't change the sentence that Judge Reeder imposed, which was 15 years broken into 3 5-year segments: custody, probation, and suspended. Did you have anything else you wanted to share?
No, I just wanted to put that out.
Okay. All right. Ms. Gibson, anything else you want to get on the record?
No, Judge.
Thank you again for moving quickly on Mr. Robinson's case. Mr. Robinson, there was another lawyer who had made an appearance on your behalf, but who needed to roll off the case. And Ms. Gibson, on very short order, stepped up and learned a whole lot about your situation and did a good job of representing you. And I guess, Ms. Gibson, you had been working with Mr. Robinson on the unindicted side of things.
Just for the past 10 days.
Okay, but which is why you're in that position to say if just nothing has happened with the complaint that was brought.
Correct.
Okay, all right. Well, thank you both. I'll get an order out today or tomorrow that addresses the sentencing piece. And then, like I said, once that's in, you will decide what, if anything, you want to do from there. Okay?
Thank you, Judge.
Thank you, everyone. Thank you, Ms. Jackson and Ms. Tucson. We'll see you guys tomorrow. We got a bunch more calendars. Maybe we'll get a plea. Who knows? Well, we've got a morning of calendar. Hold on one second.
Have a great one.
Yep. So I'm gonna let these folks go.
So Mr. Kennedy is very clear. I don't know if this one prefers, I have not learned the situation in the past, but I'm still eager to
have an offer yet. I'm always happy to go non-negotiated. I'm comfortable doing it in this courtroom. Do you have guidance for the defense on this case?
Only that folks can always plead blind. I don't know anything about it, so I'm not in a position to say, oh my gosh, with his criminal history, it's this or that. I note that it's 5 years old. And so a lot to me would hinge on what's been going on in the last 5 years. And the answer is nothing. That inures to his benefit. If it's, well, I've been in Clayton for a burglary and DeKalb in a burglary, but then that all falls back to criminal history. So the reality is no one can stop him from entering a non-negotiated plea. Not the state, not me, frankly, not you. You can put on the record, it's a terrible idea, but if that is his wish, you as his attorney need to let him do that. And if that's what he wants to do, we can do it now. We've got a prosecutor right here. I don't know if Ms. Clark, she is not on anymore. I wouldn't expect her to be on because we couldn't see the videos on Zoom, so it was less interesting. So I'm open if he's still up, but we need to get someone on the DA side.
What type of case is it?
A burglary.
Burglary from 2018.
So I don't mind stepping in. I need to at least, I gotta talk to victim contact would be my only issue.
So, and that was what Ms. Clark was concerned about as well. And I guess that's the piece where I'd push back a little bit. And we can, tomorrow is a Zoom date and we could get Mr. Kennedy in on the Zoom. And this will have given the state 24 hours to try to reach the victim. But the reality is the numbers aren't good anymore. They're not going to get better tomorrow or the next day or the next day. This calendar was published a while ago. And so if the state was seeking to get input from the victim, alleged victim, because I know it was published as probation revocation, but it doesn't mean it wasn't on a calendar. The state could have done that.
I feel bad. I've been bothering Ms. Nelson about this case, so I don't know if it's easier to try to do it today. I'm happy to do it, or if it's not a big deal to get him on the Zoom calendar tomorrow. I do have other people on that calendar.
Let me ask Ms. Nelson that. Ms. Nelson, my sense was to add someone on Zoom is less complicated than, oh, she says it's a full calendar.
Okay.
But it's also the last week before we break for the year. So Ms. Nelson's going to ask. And I bet they'll say, if we say pretty please, and we're organized tomorrow and we get through the other stuff. It depends. Is tomorrow, I haven't looked at the calendar yet. Is it a bunch of probation revocations that are going to take a long time, or it's mostly arraignments and pleas and inquiries?
I think I have one add-on probation revocation. I've already talked to him. And then I have at least one plea ready to go, hopefully another one. And then I know Ms. Feely has some arraignments that are just arraignments.
Okay, so those will go pretty quickly. And so that would be my thought. Then I'm comfortable that the state has had, really they've had a bunch of days to reach a victim, but I think we were all confused as to what it was on the calendar for. Ms. Clark has known now for a little while that it wasn't for a revocation and that Mr. Kennedy wants to work the case out. So if you want to let her know that we spoke and that if we can get Mr. Kennedy added to the Zoom crew tomorrow, that we're going to let him pursue a plea, whether the state was able to track the alleged victim or victims down or not. Okay.
Thank you, Judge.
Let me do one last thing, because
I show 5 revocations tomorrow.
Okay.
Oh, how many?
Just, she was asking 1, 2, 3, 4, 5. I count 5.
Okay.
But just Ms. Wood asked, and then on that order, Judge, did you want to type that? Because that's a little different since there was a hearing, or do I put violated by preponderance, or how?
I will reach out to you about how this is going to work. I need to talk with Ms. Nelson as well. I'm not sure.
Okay, sounds good. I'll
Sure.
be on standby.
Thank you.
All right, you have a good one.
The exhibits, I have them on a flash drive. Should I hold on to them? And
No, you should give them to me and I'll give them to Ms. Rivers, because she'll want to make them part of the record. I don't know if he's going to want to appeal it, but I mean, the help I need is